Morning everyone. Let's watch and see. And listen carefully before you comment, okay? Maingay nangyari.
We're requesting everybody to rise for the opening prayer to be led by the Honorable Congresswoman Karen Lagbas.
Let us put ourselves in the presence of the Lord. Heavenly Father, we come before you today with humility and reverence as we undertake a solemn constitutional duty. You have entrusted to us positions of responsibility, and today we ask for your guidance as we discharge that responsibility with integrity, courage, and fidelity to the rule of law. Grant us wisdom as we deliberate on matters of grave national importance. Enlighten our minds that we may discern the facts clearly. Steady our hearts that we may remain impartial and principled. Guard our words that they may reflect respect, restraint, and fairness. Remove from us any bias, pride, or personal interest that may cloud our judgment. Remind us that we are servants of the people and stewards of the Constitution, accountable not only to our institutions, but to the generations that will follow. Lord, as we carry out our work in peace within these halls, we lift up to you the many nations suffering from conflict and violence. We pray especially for those affected with the ongoing wars in the Middle East and in the other parts of the world. Comfort the innocent, protect the vulnerable, and soften the hearts of the leaders, that peace, justice, and reconciliation may prevail. May the suffering of humanity move us to act always with compassion and with a deep awareness of our shared responsibility to uphold human dignity. Trust this meeting, our nation, and our troubled world to you. All this we ask in your holy name. Amen.
You may take your seat. The meeting of the Committee on Justice is hereby called to order. Since this meeting is a continuation of our yesterday's committee meeting, the calling of the roll is hereby dispensed with. The chair will address the committee. Today, March 3, we reconvene the Committee on Justice to undertake the next crucial step in our constitutional responsibility. This is to examine the sufficiency in substance of the third and fourth impeachment complaints against the Vice President. But before we proceed with today's hearing, allow me to briefly summarize what transpired during yesterday's session. As the members of the committee will recall, yesterday, we officially began deliberations on the impeachment complaints against the Vice President. In total, there were 4 impeachment complaints. And yesterday, we took several significant procedural steps, each made deliberately, carefully, and in full adherence to the Constitution and our rules. First, we approved the withdrawal of the second impeachment complaint after the complainants expressed their decision to instead support the third impeachment complaint. This was further supported by the withdrawal of the endorsements from Representative Percy Sendanya and Representative Laila De Lima. Representative Sendanya noted that by reducing the number of complaints, the committee would effectively expedite the long-delayed impeachment process. Representative De Lima also added that this move would yield strategic gains in the future, quoting a song in the process, "It does not matter how we get there, as long as we get there." Second, we set aside the first impeachment complaint on the ground of violation of the one-year bar rule. This is by a vote of 22 in favor, 10 against, Neko, Sara Ilago, and even Representative De Lima. The committee remains committed to a prudent interpretation of the Constitution. As Representative Joel Chua said, the members are exercising caution in interpreting this constitutional limitation. Third, following the sponsorship speech delivered by Representative De Lima, we found the third impeachment complaint sufficient in form. It was timely filed, and all necessary formal requisites were duly met. The motion to find it sufficient in form was seconded and approved without objection. Fourth, after the sponsorship speeches of Representatives Paulo Ortega and Benny Abante, we likewise found the fourth impeachment complaint sufficient in form. In his sponsorship, Representative Abante invoked the values of duty, honor, and principle in stating that he could no longer remain silent, which compelled his endorsement of the fourth impeachment complaint. Like the third complaint, the fourth met all the necessary formal requisites and was approved by the committee without objection. Yesterday, therefore, we addressed form. Today, we move to substance, the heart of impeachment. And right now, we focus on only 2 complaints, the third and fourth impeachment complaints. Kung kahapon ay naging technical ang ating usapan, ngayon naman ay hihimayin at susuriin natin ang mismong laman ng bawat reklamo. Dito natin titingnan kung ang mga paratang ay umaabot sa pamantayan para sa impeachment. This is the stage where we ask, do the allegations rise to the level of impeachable offenses? Do these complaints meet the constitutional threshold to move forward? And importantly, are the allegations credible enough to justify moving forward with the process? To answer these questions, we must read the third and fourth complaints thoroughly. Parehas pong makapal ang mga ito. 98 pages ang third complaint, 72 pages ang fourth complaint, at pareho po itong may kalakip na napakaraming dokumento. Kung susumahin natin lahat, At kasama ang mga kalakip na dokumento, lampas 900 pages ang third impeachment complaint at halos 800 pages ang fourth impeachment complaint. Hindi ito biro. Ito ay seryosong mga paratang na nangangailangan ng seryosong pagsusuri. Ang bawat pahina ay may katanungan at ang bawat katanungan ay nangangailangan ng sapat na kasagutan. This is meticulous, detailed work that demands careful review and our full attention. Once again, let me reiterate, at this stage, we are not determining the guilt. We are not weighing the evidence. The only question before us is there enough in these complaints to justify moving forward with the impeachment process? Ito bang nakasaad dito? Sapat ba itong dahilan para sa impeachment? Now, I must acknowledge that yesterday was an interesting day. We witnessed a fascinating display of foresight, a moment when a colleague sought to act on a premonition to address some matter before it even happened. But today, we leave the world of premonitions behind. We are not fortune tellers. Our duty is to scrutinize the documents now before us. Our focus is to determine whether the third and fourth impeachment complaints are sufficient in substance. Now more than ever, we must recognize the gravity of our duty. We are tasked not just with reviewing paperwork, but with making sure that the Constitution is duly followed. If the allegations are worthy of consideration, it is our responsibility to proceed to the next step in holding the highest officials of the land accountable for their actions. Kaya't magpatuloy tayo ng maingat at may integridad. Let us proceed constitutionally, upholding the process set forth by our fundamental law. Let us act with the integrity demanded by our oath of office and with the transparency expected by the Filipino people. Muli, itutuloy na natin ang pagdinig para sa prosesong ito. Ang saligang batas ang ating kumpas, ang katotohanan ang ating landas. Salamat po. Now we proceed to the determination of sufficiency in substance of the two remaining complaints, the third and the fourth. We will begin with the third impeachment complaint, otherwise referred to as Father Sabalia et al. Impeachment complaint. At this juncture, we recognize the endorser, the Honorable Dilima, to make her manifestation as to the sufficiency in substance of the third impeachment complaint.
Thank you, Madam Chair. But before I do that, Madam Chair, can I just clarify? Would the presentation be on the whole complaint already, or should it be for each of the grounds? Because 6 specific grounds were alleged in the third or Sabalia et al. Complaint. Just a clarification.
For purposes of the manifestation, it should be on the entirety of the impeachment complaint, and then it will be followed by our deliberation per ground, where the endorser will be allowed, should she wishes to engage or respond to the comments and observations of the justice members.
Thank you, Madam Chair. So just a brief intro, because I'll be making a presentation actually for this grounds. Just a brief intro. As mentioned already, Madam Chair and honorable colleagues, as mentioned already, the issue before this committee is not yet the guilt or innocence of the respondent. Section 5 of the House Rules on Impeachment Proceedings clearly provides that the requirement...
Honorable Dilima, kindly speak closer to the microphone.
Thank you. Section 5 of the House Rules on Impeachment Proceedings clearly provides that the requirement of sufficiency in substance is met if there is a recital of facts constituting the offense charged and determinative of the jurisdiction of the committee. There is no issue as to the jurisdiction of the committee, and therefore the focus here, is there sufficient recital of facts constituting the offenses or the offenses charged. So at this stage, our inquiry is narrower but more precise. We are not weighing evidence. Hindi pa po tinatanong dito kung totoo ang mga alegasyon. And therefore, the question we must resolve is this: whether the allegations, if hypothetically admitted as true, would constitute impeachable offenses under Article 11 of the Constitution. Sufficiency in substance requires that the complaint alleges ultimate facts, not mere conclusions, which fall within the constitutional grounds. I humbly submit that the 98-page Saballa et al. Complaint contains not just ultimate facts, but actually detailed narration of recital of facts. Let us be candid. We are not new to the facts alleged in this complaint. Hindi po ito mga allegasyong invento o haka-haka lamang. They have been the subject of legislative inquiries, media scrutiny, and official documentation. The Filipino people have heard them. The institutions, even this very House, have confronted them. And when repeated, documented, and publicly acknowledged acts point toward willful constitutional violations, this chamber cannot pretend unfamiliarity. Our constitutional duty is not to rediscover these facts, but to determine whether these established facts constitute offenses that amount to impeachable grounds. So doon na po tayo sa complaint, sa Saballa et al. Complaint. Alam niyo po, yung presentasyon sa complaint na ito nagsimula sa statement of facts. And these are the facts in relation to the specific grounds. And then nagkaroon po ng discussion na tinatahi, linilink yung bakit yung mga facts na yon ay constitutive of impeachable offenses. So, for the guidance of the committee, the complaint sufficiently substantiates 5 general constitutional grounds: culpable violation of the Constitution, bribery, graft and corruption, other high crimes, betrayal of public trust. Pagkatapos naman po, the complaint contains a statement of facts, narration. These factual allegations as laid out are not isolated from the constitutional grounds for impeachment. Rather, several of them are intertwined with, and in some instances, subsumed under the 6 grounds for impeachment alleged in the complaint. So ang aking pong presentation, ipapakita ko na po kung ano yung mga examples, kung ano yung mga importante mga factual allegations, and then I will link it to the discussion of why they are constitutive of the offense charge as enumerated in the Constitution. So first ground, ito po yung facts in relation to VP Sara's anomalous disbursements of confidential funds as Vice President and head of the Office of the Vice President. Covered po ito ng paragraphs 20 to 71, pages 4 to 25 of the complaint. Makikita niyo po sa screen yung mga specific examples or specific allegations of facts na nandito po sa complaint. Sa aking pong presentasyon ngayon, I tried to paraphrase these averments para mas naiintindihan, mga tinagalog ko nga po yung iba, para naintindihan. So it's just really an overview of what you see in the screen as constituting the allegations of facts. So sinasabi po, barely months into office, on August 22, 2022, VP Sara requested 250 million in confidential funds from the DBM for the OVP's good governance program, supposedly. That's paragraphs 22 to 23. Only 125 million was approved for release in the last quarter of 2022. That's paragraph 24. Itong 125 million na ito ay in-encash, inilagay sa 4 na traveling bags at dinala sa OVP. That's paragraph 27. Sa utos umano ni VP Sara, iniabot ito kay Colonel Raymond Dante La Chica at ibinigay sa ibang tao That's under paragraphs 27 and 31. So kasama po yan sa linalaman ng affidavit ni Ramil Madriaga, which is Annex A. Para mapagtakpan kung saan napunta ang 125 million ayon sa ulat ng OVP, sa loob ng 11 araw, ang perang ito ay na-disburse sa mga safe houses, rewards, supplies, aid, and travel. That's paragraph 38. Nilagdaan ni VP Sara ang liquidation report, paragraph 39, Annex B, at pinatotohanan legal ang paggamit ng pondo, paragraph 40, Annex C. Naglabas ang COA ng Audit Observation Memoranda, AOMs, dahil sa kakulangan ng documentary evidence of payments or yung DEPs sa mga disbursements, paragraphs 42 to 44. Nanatili ang questionableng reward payments at ng tables, chairs, at desktop computers na walang malinaw na kaugnayan sa confidential operations. That's paragraphs 46 to 7. Ang nakakapagduda, ang 158 acknowledgement receipts ay may petsang December disbursement, habang ang iba pa ay walang petsa. That's paragraphs 48 to 49. Dahil dito, naglabas ang COA ng Notice of Suspension at Notice of Disallowance na sumasaklaw sa 73,287,000. Paragraphs 51, 53, Annex E. Bukod dito, noong 2023, 3 beses pang nag-withdraw ang OVP ng TIG 125 million na may kabuang halaga na 375 million. That's paragraphs 55 to 57. Noong 2024, muling napansin ng COA ang kakulangan sa dokumentasyon, paragraph 58. Sa House investigation po, before the House Committee on Good Government and Accountability, lumitaw ang mga resibong pirmado ng mga pangalang nakakaduda. Milky Sequoia, Kokoy Villamin, Mary Grace Piatos, at marami pa, na may inconsistencies as hindi matukoy na identity. May ilang pangalan na walang PSA records, may mga resibo na hindi mabasa, walang petsa, o nagpapakita ng mahigit 100 disbursements sa isang araw, kabilang ang mga resibong nakapetsa sa panahong wala pa ang pondo. That's paragraphs 61 to 69. What began as a 125 million confidential fund release evolved into repeated cash withdrawals, unsupported liquidations, audit findings, and disallowances. Hindi po ito isolated incident. The allegations describe a continuing pattern of disbursement without verifiable documentation, raising questions on accountability in the use of confidential public funds. These are pleaded facts of documentary irregularities and simulated liquidation. Madam Chair, these allegations, specific amounts, specific control, specific certifications, specific COA actions, spurious receipts, fictitious identities, continuing disallowances, and obstruction are ultimate facts. Kung ipagpapalagay na totoo yung mga alegasyon na pong yan, they constitute culpable violation of plunder through malversation, technical malversation, graft and corruption, other high crimes, and betrayal of public trust. With the permission of this honorable committee, tie up ko na po sa specific grounds yung mga ultimate facts o yung mga essential factual averments. Culpable violation of the Constitution. So, a culpable violation is not a mere technical breach. Ito ay sinasadya at mulat na pagsasawalang bahala sa tungkuling konstitusyonal. Inaasahan sa mga opisyal na maging tapat sa tungkulin at sumunod sa batas. The complaint pleads ultimate facts, as I said, of custody, control, and affirmative acts. Paragraphs 149, 151, and 153 further allege that VP Sara was the accountable officer for over 500 million pesos and that no disbursement could occur without her approval. Paragraphs 154 to 155 allege she directed the preparation, encashment, and delivery of 125 million. These are not passive omissions. These are affirmative exercises of authority. The complaint further alleges repeated COA audit findings, a notice of suspension and disallowance, backdated acknowledgement receipts, and non-existent signatories, and alleged interference with congressional inquiry. Taken together, control, approval, audit red flags, simulated documentation, and alleged obstruction, these pleaded facts, if admitted as true, constitute a willful breach of constitutional fiduciary duty. Graft and corruption. Kung ipagpapalagay na totoo ang mga alegasyon, pumapasok ito sa Section 3E ng RA 3019. Ang pag-encash at pag-disburse ng 125 million sa opisyal na kapasidad, kasabay ng backdated receipts, fictitious names, at paulit-ulit na COA findings ay nagpapakita ng evident bad faith. At dahil may hindi bababa sa 73 million na may notice of disallowance, malinaw na may undue injury to the government. Ang ganitong pattern ng unsupported disbursement ay sapat upang bumuo ng graft and corruption. Other high crimes. Alam niyo po, other high crimes, just like betrayal of public trust. More encompassing, because these are not confined, high crimes are not confined to technical penal definitions. They encompass serious misconduct that fundamentally undermines constitutional governance, including any act, omission, or course of conduct that renders a public official unworthy to remain in office. Kabilang dito ang mga gawain o asal ng mga opisyal na maaaring maging pamantayan para tanggalin sa katungkulan. Ang maling paggamit ng confidential funds, simulated liquidation, at paghadlang sa mga mekanismo ng oversight ay tuwirang nagpapapurol sa mekanismo ng pananagutan ng mga institusyon. If admitted as true, such conduct erodes confidence in high office and disrupts the faithful execution of the laws, which makes the VP unworthy to remain in office. That rises to the level of other high crimes. Betrayal of public trust does not require penal conviction. It asks whether the alleged conduct renders the official unworthy of the trust reposed in the office. Confidential funds operate largely on institutional trust. Kung ang 500 million ay inilabas ng cash, may questionableng dokumentasyon, paulit-ulit na na-flag ng COA at sinundan pa ng umano'y pakikialam sa oversight, kung ipagpapalagay na totoo ang mga ito ay malinaw na pagtataksil sa tiwala ng bayan. That is not an administrative lapse. That is gross faithlessness in the stewardship of public funds. Pwede na po ba ako mag-proceed sa second ground, Madam Chair?
That supports only the first article of impeachment, your first ground.
Yes,
Yes,
Madam
but
Chair.
if you can please shorten your manifestation with respect to the 5 succeeding grounds, because I understand you have 6 grounds in total for the third impeachment complaint.
Yes,
because
Madam.
anyway, during the deliberation, you will be allowed to respond to the comments and observation of the justice members.
Madam Chair,
The Honorable Rodriguez.
may I request that we go ground by ground? The presentation of the Honorable former Senator, former Secretary of Justice, Congresswoman Laila, is that there's a first ground properly enumerated. So if possible, we can now comment on the presentation and also the ground number 1 of the complaint of the Father Saballa. May I therefore request that we do that ground by ground. Thank you, Madam Chair.
The request of the Honorable Rodriguez is to open the deliberation immediately after her manifestation for the first ground of the impeachment complaint.
And for
Right?
Madam Chair, for each ground for that matter.
For each ground, yes. And you just concluded with the first ground.
Yes, Madam Chair.
Okay. So, perhaps for continuity of the flow of our discussion, we will be abiding to the request of the Honorable Rodriguez that after the manifestation for the first ground, we will be opening the floor for deliberation on the first ground, summarize the discussions of the endorser. The first ground for the third impeachment complaint, Vice President Duterte committed culpable violation of the Constitution and betrayed the public trust by committing plunder and/or malversation, graft and corruption, and other high crimes in amassing and converting the amount of not less than 500 million pesos from the confidential funds allocated to the office of the Vice President for the years 2022 and 2023. With that, we are opening the floor for comments and manifestations of the Justice members.
Madam Chair.
The Honorable Franz Legaspi is recognized.
Madam Chair, just a very quick, short manifestation, but if we, since we're now going to go over this ground by ground, I'd just like to perhaps make the general manifestation that the Honorable Ayla de Lima's recital of facts, she did conduct this recital of facts alleging the first ground of impeachment. So before we begin our discussions to the for this particular ground, I'd just like to say that on a procedural aspect, we have she has complied with the recital of facts as clearly seen in the presentation earlier. I want to commend her for the succinct, very organized way of presenting these, and I hope that this may serve as a guide for the rest of the committee members into the discussions today. So thank you, Madam Chair.
All right. Any other member who wish to make a manifestation with respect to the sufficiency in substance of the first ground as presented by the endorser, the Honorable De Lima?
Madam Chair.
Honorable Lord Ansuan.
Madam Chair, impeachment must remain a shield of the Constitution, not a sword of politics. The moment we lower its threshold for any reason, we weaken the very democracy we claim to defend. That is precisely why we must carefully examine the factual allegations and ensure that the constitutional standard is strictly met. In that spirit, and solely for the purpose of determining sufficiency in substance under our rules, may I respectfully request the Honorable Endorser to clarify on record what the specific pieces of evidence were referred and appended to the complaint which would support these allegations.
Honorable De Lima.
Thank you, Madam Chair. Although I wish to state first at the outset that in dealing with the issue on sufficiency in substance, we do not really inquire first into the evidence. But of course, in terms of really substantiating the essential grounds, the essential facts as pleaded, we can always check whether there are supporting evidence or annexes as submitted, as attached to the complaint, and later to be supplemented by other evidence in the proper time. And the proper time is during the evidentiary hearings. Kasi pagkatapos ko kasi ng pag-file ng answer, pag-file ng reply, pag-file ng rejoinder kung meron, pwede pa hong magdagdag ng mga ebidensya, including affidavits doon. So just to satisfy the gentleman that yes, we have supporting documents, supporting evidence. The attachments consist of exhibit Annex A to Annex CC or double C. And most of these are actually already, these are photocopies of the public records, electronic copies of which have been uploaded to the official website. I'm referring to Annex A. But to the others, the originals of this documentary evidence are the House's own records of files. So what we have are photocopies of certified true copies of those documents. These are the liquidation reports, the accomplishment reports of the OVP, the COA notices of disallowances, the OVP certification, the OVP accomplishment reports, letter to Chair Cordoba, mga the documents evidencing payments, the photocopies of the documents evidencing payments, at doon nga yung mga nakikita rin yung mga fictitious names. So there are sample DEPs or the documents evidencing payments, and then the audit observation of COA, other certifications of DepEd. No, we're not into DepEd yet. So we're under the first ground, the anomalous disbursement of the confidential funds allocated to the Office of the Vice President as the VP, as head of office. So meron po, dito po, nakalakip, naka-attached, most or many of those documentary evidence, pero ngayon, photocopies lang muna ang pinipresent dito o inattach dito sa ating complaint, sa third complaint. Kasi hindi naman po kailangan at this stage na magpresenta na ng photocopies. And if I must tell the Honorable Committee, meron na nga pong bagong rule sa ating rules of court na maski photocopies ay pwede, can be admitted, even is not the original, unless a genuine question is raised in the authenticity of the original, or under the circumstances it is unjust or inequitable to admit the duplicate in lieu of the original. Clear po yan sa sections 3 and 4 of Rule 130 as amended. The photocopies are attached, and these are photocopies that are admissible to the same extent as the originals. These are duplicates to the originals under the House's custody. So that is our position, na hindi kailangan unless authenticity is questioned at the proper time. And again, that would be at the evidentiary stage. But even that, handa po ang complainants to present yung certified true copies, which actually form part already of the records of this House.
In summary, Honorable De Lima, your attachments in support of the first ground include COA documents and the transcript of hearing of the House of Representatives.
Yes, Madam Chair.
Honorable Suwan?
Just to clarify, Madam Chair, may I ask the Honorable Endorser, in what manner these annexes, these affidavits, notices of disallowance establish a clear nexus between the respondent and the alleged acts in such a manner as to possibly justify the advancement of this complaint beyond this committee?
Yes, I have actually explained, Madam Chair, I have actually explained that earlier, that as the head of office, as the Vice President, the Office of the Vice President, she approves the disbursements, she approves the liquidation, she approves the accomplishment reports. So there is control on her part of the disbursements, and there is testimony to the effect that the instruction to give to various persons not contemplated within the object of confidential funds ay through the orders of the Vice President. So may pattern po of disbursement without verifiable documentation, documentary irregularities, and stipulated liquidation. So under the principle of command responsibility, it is clear that she is the head of office. She approves those disbursements, and also in submitting the excuses under the accomplishment reports, which were found to be not valid by the COA on the audit findings of COA.
Just for the record, Honorable De Lima, when you made mention about approved, she approves the request, she approves the disbursement, does this mean as well that she is the signatory in all the necessary forms?
There are some that she is the signatory, but many also she's not the signatory, but that is supported the fact that it is within, or it was within her imprimatur, that those disbursements are made, those liquidation vouchers were approved were actually testified on by the proper officials of the Office of the Vice President in the course of the previous House hearings.
May we confirm as well that in several documents that you attach or the complainants attach to the impeachment complaint, will this bear at least the signature of the Vice President?
Some of them.
All right.
Some of the aspects are taken care of by the testimonies of the responsible officials also of the Office of the Vice President, because the Vice President herself is the ultimate responsible officer in the disbursement of and the use of these confidential funds.
Thank you. Any other more question? Any other member who wish to manifest on the first ground of impeachment of the third impeachment complaint? The Honorable Suntay?
Thank you, Madam Chair. Madam Chair, sa ating mga kasamahan dito sa komite, bago tayo pumasok sa substance ng complaint number 3, mahalagang balikan muna natin ang tungkulin natin sa ilalim ng rules of impeachment. Ang mandato ng komiting ito ay simple, ngunit mabigat. Tiyakin ang bawat impeachment complaint na dinala sa kapulungan ay pumasa sa pamantayan ng batas. Kaya ang panawagan ko sa bawat miyembro ay pairali natin ang parehong antas ng pagsusuri na inaasahan sa anumang legal proceedings. Maingat, patas at walang kinikilingan. Ang tanong sa harap natin ngayon ay hindi kung political controversy, kundi kung ang complaint ba ay naglalaman ng ultimate facts. Na kung ipagpapalagay na totoo, ay bumubuo ng impeachable offense sa ilalim ng Rule 3, Section 5. Mahalaga rin tandaan natin na meron na tayong established standards ang komiting ito. Dahil ng ilang linggo lang nakaraan, dumaan rin sa komite na ito yung impeachment complaint laban sa Pangulong Marcos. Mula sa mga naunang disposisyon ng impeachment complaints, malinaw na sinabi ng komite na ito na hindi sapat ang mga aligasyon na nakaantabay lamang sa administrative process, audit observation, o konklusyon na walang malinaw na factual particulars tulad ng unlawful acts, personal participation, o personal gain. Sa parehong pamantayan na yun, dapat natin suriin ang complaint 3 and 4. Kung ang mga aligasyon ba ay tunay na naglalatag ng impeachable offense o kung ang mga ito ay naglalarawan lamang ng mga pangyayaring hindi pa naman napapatunayan na iligal na gawain. Ang diskusyon na ito na nais kong buksan ay nakatuon dito sa pamantayan na ito. Now, dadako na ako sa aligasyon. On complaint 3, naisaad na on August 22,
If I may interrupt, Honorable Suntay, we are deliberating on a per ground basis.
Yes.
We are only on the first ground.
I'm on the first ground, Madam
Thank you.
Chair. It was just an opening statement. On August 22, 2022, as alleged, VP Sara requested an additional amount of 200 funds, as was stated by the Honorable Congresswoman Daila de Lima. The allegation establishes only that the respondent requested confidential funds. Requesting funds is part of the budget execution process and is not illegal per se. The complaint does not allege that the request violated any law or constitutional prohibition. Thus, no impeachable offense was pleaded. On paragraph 24, it stated only 125 million was approved for release for the Office of the Vice President. It's very important also to note that 125 million came from the Office of the President, which was downloaded to the Office of the Vice President. The allegation confirms that the requested funds were reduced and approved by the proper authority. Sino yung proper authority that authorized the downloading of funds? It was the President, because the funds came from the Office of the President. The complaint does not allege that the respondent unlawfully caused approval. Approval of funds is an act of the Executive Budget Authority. not the respondent alone, as I mentioned. On paragraph 25, it stated that on December 20, 2022, a disbursement voucher in the amount of 125 million was signed by VP Sara. But the signing alone constitute an impeachable offense? Signing of a disbursement voucher is a ministerial or administrative act necessary for fund release. The complaint does not allege that the voucher was falsified or illegal. Therefore, the paragraph does not plead any unlawful overt act. On paragraph 27, the cash was placed into 4 traveling bags. VP Sara was, as alleged, even assuming that the instructions was given. The allegation describes operational handling of confidential funds. Dahil ang disbursement ng confidential funds, hindi naman cheque ang ini-issue sa mga confidential agent. Naturally, you would need cash to disburse for to be distributed. At 4 p.m., as alleged on paragraph 28, December 20, Acosta gave, ito yung tungkol sa handling raw ng funds, Colonel La Chica gave the full amount of 125 million. The paragraph describes a transfer between subordinates. No allegation is made that the respondent received the funds or personally benefited, which is very important, yung personal benefit. Handling of funds, the distribution should benefit someone. We are trying to impeach the Vice President. Does this distribution of money, of the confidential funds, ultimately benefited the Vice President? I read through all the entirety of the complaint, and there is no specific allegation that the money was indeed, that the money indeed went to the Vice President. On paragraph 37, using her subordinates and the VPSG, this is a conclusory allegation unsupported by factual details. The complaint does not specify the amount allegedly taken, the benefit obtained, the assets acquired. Under Rule 3, Section 5, conclusions do not constitute ultimate facts. The complaint further alleges
Uy, nag-hang up si Madam. Baka nangyari? Nangyari?
Okay, start this up. Yeah, I know you ain't been no angel.
What happened?
All the times you got my heart in the danger.
memorandum is a preliminary audit finding, requesting clarification. It does not establish liability nor show that respondents personally falsified documents. It was also alleged that COA issued a notice of disallowance on August 8, 2024 for items totaling 73 million. But the notice of disallowance establishes potential administrative liability subject to appeal. It does not automatically establish criminal conduct or an impeachable offense. Now, ang kailangan natin malaman, is there a final audit observation issued by the COA? O wala? Because I was going through the complaint, there was no mention of a final audit observation. If there was, then it has to be, it was not contained in the complaint. So, Madam Chairman, with regards to the first allegation, On my part, these are my observations. Thank you very
Thank
much.
you. Since I observe that we are beginning to become passionately engaged in our deliberation, I am reminding the justice members to limit the manifestation into 5 minutes, and the committee secretariat are requested to be observant on the allowable time given to each member. May we ask the endorser to comment, to respond to the observations of the Honorable Suntay.
Madam Chair, may I request that he will hear first all the observations so that he will have an entire response.
If for the sake of continuity of the flow
I have
of thoughts,
also my
same observation?
I have different observations.
Yes, let us hear first the comment of the endorser to the observation of Honorable Suntay, and then we will be calling you Honorable.
Thank you. As I mentioned earlier, all these expenses or all these disbursements and spending of the confidential funds. Malinaw po na sinaad sa paragraphs 149, 151, and 153 that VP Sara was the accountable officer for over 500 million and that no disbursement could occur without her approval. And it was also further alleged that she directed the preparation, encashment, and delivery of 125 million. Meron hong testimonya na sinasabi na yung mga yon, yung mga funds na yon ay hindi naman talaga nagamit dun sa mga dapat ipaggamit ng confidential funds. And then kanina po, yung sinabi po ni Congressman Suntay, dun sa wala namang sinasabi doon na mali yung pagkakagamit ng mga confidential funds. May I direct the attention of the Honorable Committee, Annexes C, F, H, and I are certifications that says expenses were incurred with agencies, intel, and confidential operations. And based on the audit observation memoranda issued by the COA, ay ito ay hindi naman talaga na ginamit dun sa mga totoong purposes of the confidential and intel funds, but actually were wrongly disbursed to wrong persons and for the wrong purposes. Yung paggamit ng mga confidential funds na katulad ng ginagamit para sa safe houses, sa tables and chairs, sa laptops, nakasabi po yan lahat dito, at that is a misuse of confidential funds alongside yung pagtatakip rin. Kasi remember, when the committee then requested from COA, any finding, any certification with respect to the spending of the OVP's funds, pinigilan pa nga ito ng kanyang chief of staff na wag gawin ng COA. This is a form of obstruction, and that is under her instructions. And clear po sa mga dokumento na ito na mali talaga yung paggamit ng mga confidential intel funds. Nakita natin yung mga acknowledgements, receipts ng mga which appear to be questionable and fictitious names. These were approved by the Vice President herself. May pirma siya sa certain documents as attached. So I don't see the validity of the argument na walang proof na may kinalaman si VP sa paggastos ng mali ng confidential funds ng Office of the Vice President.
Thank you. Again, for purposes of an orderly deliberation, except for the manifestation which is tantamount to sponsorship with respect to the determination of sufficiency in substance, the questions and manifestations of the justice members are limited to 5 minutes. The answer of the endorser is limited as well to 5 minutes. If you wish to continue with your point of argument, you will be given your opportunity on the second round. That is in the interest of fairness and equality because the other members wishes to make their manifestation as well. So I will be calling the Honorable Rodriguez, and if there will be no more members aside from Kong Jokno, we will be going back to you, Honorable Suntay,
Reply.
after the first round. Honorable Rodriguez.
Thank you, Madam Chair, distinguished colleagues, the respected endorsers. Let me just comment first on the prefatory statement. Yesterday, I really acknowledge the statement and the lyrics given by the Honorable De Lima on whatever you go to come here, get here, by train, by car, by plane, by boat. And that is the song, Get Here, by Oleta Adams. Thank you. But in the prefatory statement, it seems that the prefatory statement is from the man from La Mancha, the impossible dream. I like to ask, is the quest to impeach the Vice President an impossible dream?
Not at all.
Okay, so the prefatory statement should have been changed. There should be something more positive than negative. Otherwise, impossible dream is an impossible dream. But anyway, I go now, Madam Chair, to the grounds. We will methodically go into the grounds to try to go to trial against the Vice President. So, number one, the first ground is Vice President Duterte committed culpable violation of the Constitution. There is none. There's no direct. We cannot have a violation we have to discuss because there are many underlying grounds for betrayal of public trust. The first one as stated in the complaint is committing plunder. Madam Chair, plunder is on the Republic Act 7080. You have to put in here all the elements. Misuse or malversation of public funds. Receiving the commissions. He receives the money, the kickbacks. You see? Illegal fraudulent conveyance of assets or taking advantage. Now, malversation. Malversation is governed, Madam Chair, by the law on Article 217 of the revised penal code. So there are also requirements for malversation to support betrayal of public trust. And the elements here is that the offender is public officer and, as decided by the Supreme Court, she should be an accountable officer. The Vice President is not an accountable officer. Oh, who are the accountable officers? By definition, according to the Supreme Court, accountable officers are cashiers, treasurers, property officers, and the like. She is the Vice President. And so therefore, this malversation cannot prosper as stated directly. However, this is where it will be. However, there is allegation here that there is conspiracy. Ayan. The accountable officer, if there is conspiracy by the head of office, under the ruling of the Supreme Court, there may be malversation through conspiracy. And that is what they are going to therefore make as a support for committing betrayal of public trust. And then, graft and corruption. It is governed by Republic Act 3019, Article 3. So, paragraph 3, E, F. And there is also no clear allegation that because of his office, he gave due advantage or she received kickbacks. This is confidential funds. And so therefore, Madam Chair, we could not also say that there is graft and corruption. Secondly, and lastly, other high crimes very far from it. In this case, the allegation is that there is a misappropriation of 500 million in the OVP. 125 of that was 2022, 375 in 2000. Now, what is the status now of that particular finding by the COA? Madam Chair, the COA saw that there is lack of funds, lack of supporting documents, documentary evidence of payments. But there is no COA finding of corruption of the Vice President. This is just the lack of documentary evidence of payments to the respective beneficiaries. And then we also have, Madam Chair, in this case, Graft and corruption is defined, the Supreme Court said this is about 3019. So in this case, there is no, when did the Vice President receive the money? Where was it deposited? So, therefore, receiving these gifts or kickbacks under under 3019.
If I may interrupt, Honorable Rodriguez, you are more than 5
I'm
minutes,
just going
so
to wind
kindly
up,
wrap
Madam Chair.
up.
I'm just going to wind up. And then other high crimes, it is far from other high crimes. So therefore, Madam Chair, these are my observations, and we are going to say, and I'm going to state here, that as far as betrayal of public trust, there is a recital of facts sufficient.
Yes.
Substance in substance to go to trial. The particular case here, there was observation, audit observation, and there was notice of disallowance. That's correct. But then the Vice President has appealed this to the Commission on Audit. As to allegations found by our committees on various matters, these are to be explained in the trial.
Yes.
And so therefore, I find that the first ground, there is substance in substance of this form. Thank you, Madam Chair.
Honorable De Lima, your comment?
I absolutely agree with the Honorable Rufus Rodriguez with respect to his summation that these are constitutive of betrayal of public trust. Now, it's not an argument that the other grounds, culpable violation of the Constitution, graft and corruption, graft and corruption, and yes, the culpable violation of the Constitution and graft and corruption do not plead, or there's no corresponding allegations with respect to them. Because when we talk about culpable violation of the Constitution, we are centered on the principle of public office is a public trust. And therefore, if there's a betrayal, I just got a list of the annexes where nandyan yung mga signature ni VP Sara, Annexes C, D, D-1, ni VP Sara, Annexes C, D, D-1, F, G, H, H-1, I-1, Q, R, R-1, R-2, S, S-1, S-2, T, and V3, V-3. Those documents attached to the complaint, and these are certified that the other grounds, culpable violation of the Constitution, graft and corruption, graft and corruption. There's disbursement that are highly questionable and illegal. These are also meant for persons not within the contemplation of the spending or expenditure of the confidential and intelligence funds of any office. So betrayal of public trust, I agree, this is the strongest ground that encompasses all of the other allegations subsumed in this ground number 1. Thank you.
Thank you, Honorable De Lima. Now we recognize the Honorable Chel Jokno.
Thank you, Madam Chair. Good morning, everyone. Pursuing that same point, Representative De Lima, I noticed that with respect to the 125 million that was spent from December 21 up to December 31, 2022, there were 2 documents that were signed directly by the Vice President. One is a liquidation report attached as Annex B to the complaint. And the certification, the signature of the Vice President appears below the words certified, purpose of cash advance duly accomplished. And I believe that I would like to hear from the endorser the significance of that, because to me, that is not only an issue of command responsibility, that is a direct certification made by the Vice President that the cash advances of 125 million, which were spent only in a period of 10 days, the purpose was duly accomplished. Second, there is another annex, Annex C, which also bears the signature of the Vice President, a certification where it is stated that the expenses, again, the 125 million spent in December of 2022, those expenses were incurred in connection with the agency's intelligence and or confidential operations and activities. And that document is signed again by the Vice President and under the word attested. So I would like to hear from the endorser whether what she thinks is the significance of these two documents signed directly by the Vice President. Thank you, Madam
Honorable
Chair.
De Lima.
Thank you, Madam Chair. It says full awareness, the certification, the attested, well, correct. That is more than just command responsibility, but is in fact direct knowledge with direct information as to the contents of the certification, that these are used for certain supposedly lawful purposes, but they turned out to be not so in accordance with the audit, with the COA audit memoranda. The findings also that came out during the hearings before the Committee on Good Government and Public Accountability. So this is personal and direct knowledge and supporting the veracity, establishing supposedly the veracity of the contents again of the certification. So she perfectly knows that what were included in the certifications turned out to be not the legal purposes for confidential funds.
Just for the record, Honorable De Lima, kindly restate the content of the certification.
Next is
Just to form part of the transcript of records.
Annex C.
Just the content of the certification.
Yes, Madam Chair. We hereby certify that the amount of 125 million pesos was incurred by the undersigned in connection with safe implementation of OVP initiatives and confidence building from the cash advance drawn on December 20, 2022 in the total amount of 125 million. We further certify that A, the certifying officer or employee is accountable for the disbursement from the cash advances of CF and or IF. B, the expenses were incurred in connection with the agency's intelligence and or confidential operations and activities with supporting documents attached to the liquidation of CF, and for the IF, documentary evidence of payments kept in sealed envelope in the vault in the office of the SDO. C, the details and supporting documents of transactions that are classified are in the custody of the agency and kept in the vault, which may be inspected by IFCAU if the circumstances so demand. D, the funds are not used for payment of salaries and wages, overtime, additional compensation, allowance, or other fringe benefits of officials and employees, representation, entertainment expenses, consultancy fees, and construction or acquisition of buildings or housing structures. E, the purchase of equipment is relevant to the confidential and or intelligence activities, and the expenses are necessary and utilized for legal purposes. Signed, Special Disbursing Officer Gina Acosta, attested Sara Duterte, Vice President. So he's fully aware, she attested to the fact that there were such expenses, but it turned out that many of them were not really meant for the supposed legal purposes, objectives of intelligence and confidential funds, as it turned out during those hearings, based also on certain testimonies from the disbursing officer and other officials, accountable officials of the office of the Vice President. That's just an example. That's just a sample of a certification signed or attested by the VP herself.
That is an actual certification.
Yes, Madam
Yes.
Chair.
Of the various expenditures.
Various expenditures, there are several
Which means that there are similar certifications supporting other expenditures.
Yes, Madam Chair.
Thank you. The Honorable Chua is recognized.
Thank you, Madam Chair. Madam Chair, let us assuming tama po yung sinasabi ni Congressman Bong Suntay na tama po siya kanina. Ito nga pong mga pondo, kung paano po tinransfer sa OBP, talaga naman pong doon po, wala naman tayong nakikita talagang pagkakamali pa. And in fact, trabaho po to ng Vice President as head of agency, mag-disperse, tama po ba? Lahat po ng mga dokumento, pumirma kung ano po dapat niyang pirmahan. Tama po naman po yun. Subalit po, titignan po natin, dito po sa paragraph 27. Sabi po dito, the cash was placed into 4 traveling bags and brought to the OBP on the same day. Thereafter, BP Sara instructed Acosta to release the 125 million pesos to Colonel La Chica. At dito po, sabi po dito, Acosta, pursuant to VP's instruction, personally gave Colonel La Chica the full amount of 125 million pesos. Now, my question is, ang SDO po ay si Acosta. Ano po ang papel ni Colonel La Chica dito po sa 125? And that is upon the instruction of the Vice President. Dito po ba, wala po tayong nakikitang diferensya? Now, if I remember it correctly, during the committee hearing, marami po nagtanong, after La Chica, ano na? Yun, dito po natin makikita ngayon, papasok yung statement ni Madriaga. The affidavit of Ramil Madriaga, which was attached as Annex A of this complaint affidavit, or dito po sa impeachment complaint, which can be found on page 13. At dito po sa statement ni Ramil Madriaga, sinabi po niya, and I quote, makikita po dito yung conversation sa page 29, sa paragraph 29, 30, 31, 32. Sabi po dito, Colonel Dennis Nolasco sent a certain Ramil Madriaga a text message instructing him to see the former. So Madriaga went to see Colonel Nolasco at Ultra Pasig City. He arrived at the place around 1:30 p.m. Next, they waited for Colonel La Chica. Ito na po si Colonel La Chica. In 2 DepEd vehicles that ultimately arrived past 3 p.m. Upon arriving, Colonel La Chica brought 4 duffel bags containing millions of peso. So ito na po yung duffel bags na winidraw po nila sa land bank at binibigay ngayon kay Madriaga. In particular, paragraph 32, Colonel La Chica instructed Madriaga to deliver a duffel bag to a mayor in Laguna. Hindi ko po alam kung yung mayor po may kinalaman sa intelligence gathering. So Madriaga delivered it to a certain individual at Cabuyao, Laguna. Then he was told by Colonel La Chica to deliver another duffel bag to a comedy bar owned and frequented by San Sebastian law alumni located in the Timog area. Paragraph 33. When Madriaga arrived at the place, he saw OBP spokesperson Raymond Monsayak. Parenthetically, Monsayak was BP Sara's classmate. Subsequently, Monsayak signaled Madriaga to go upstairs and leave the money at the office. He followed suit and left. Monsayak did not speak to him. Paragraph 34 says, next, Madriaga drove a car to the parking compound of the Office of the Ombudsman, he also brought another duffel bag of money and placed it inside the car. When he arrived at the Ombudsman compound, a guard signaled for him to park in a specific reserved spot, and he did. He placed the keys on top of the left front wheel and left. He then saw someone retrieve the keys and drive the car away. Within the same period, Colonel Nolasco gave Madriaga a white Toyota Vios with money in the amount of around 80 million pesos. Following Colonel Nolasco's instruction, Madriaga drove the white Vios to a parking lot inside SM Mega Mall, parked and locked the car, placed the keys on top of the left front wheel, and moved away. He then waited for someone who retrieved the keys and drove off. On another day, Madriaga saw the same motor Vios driven by the wife of Ombudsman Prosecutor Ryan Ray Kilala, named Rhea, who was a classmate of BP Sara at San Sebastian Law. Now,
If I may interrupt, Honorable Chua, you are more than 5 minutes,
yes,
so
I will
kindly wind up.
I will already wrap up my statement. Madam Chair, dito po yung sinasabi kanina ni Congressman Rupos na conspiracy. So dito na po napunta yung sinasabi po ni Congressman na hinahanap po natin kanina yung 125 million with all the documents. Kaya po yung COA naglabas ng AOM, naglabas ng kung ano-ano mga pangalan na eventually nakita po natin yung mga pangalan ay hindi makita ngayon. So ito na po yung sagot sa tanong kung saan po napunta yung pera na binigay kila Chica. Base po ito sa affidavit ni Madriaga, which is attached in this complaint. So therefore, there is a recital of facts which constitutes the offense charge. Thank you po.
You read the name of Nolasco and La Chica. Just for the record, Congressman Joel Chua, who are these personalities? Nolasco and La Chica. You read that from the affidavit.
They are both, I think, security details of the Vice President.
Nolasco and La Chica.
Yes.
Thank you. Would you like to comment, Honorable De Lima?
To add,
Yes.
yung mga ninarrate po na based on the complaint ni Honorable Congressman Chua, pinapakita po na yung 125 million na yon hindi napunta sa dapat puntahan ng such a sensitive funds as confidential or intelligence funds. We can actually say that these were simply appropriated by VP Sara for her personal gain. Kapag hindi napunta dun sa dapat puntahan, at sabi nga sa affidavit ni Ramil Madriaga, ay ito ay napunta sa iba-ibang tao na ano ba sila? Hindi naman sila part of anything. Well, at wala namang sinabi, there was no report, neither the Vice President nor the OVP reported any loss of the 125 million confidential funds. Dahil nga, napunta sa mga ganyan. So that is actually personal gain for our own personal purposes, whatever it is. Bakit napunta dun sa mga personalidad na yon as testified to by Colonel Lachica and Colonel Nolasco, which are part of the Office of the Vice President Security Detail. These are actually the head. Nolasco is the head, and also Lachica is, sila talaga yung mga supposedly pagkakatiwalaan ng Vice President. And so, it shows personal gain. Gusto ko lang pong sabihin at this point, na tungkol naman po sa plunder, yes, I agree that it's more of a conspiracy. So it's a better, it's a better theory than just plunder, because plunder committed through conspiracy. Let us remember po na pang malversation of public funds, it's plunder committed through a series of acts of malversation. So a series of acts of malversation can lead to plunder, especially if it meets the monetary threshold of 50 million or more than 50 million. Thank you.
Any other member who wished to manifest on
Madam-
the first ground? The Honorable
Madam Chair.
Marcoleta.
Thank you, Madam Chair. Madalas pong binabanggit yung notices of disallowance and audit observation memo. Para po sa akin, ito po ay mababaw na ground to constitute an impeachable offense. Unang-una po, ang notices of disallowance ay appealable. They are contestable. Yung pong audit observation memo is just a memo issued by the COA for deficiencies in documentation not involving pecuniary loss. Ang notices of disallowance po ay pwede pang i-appeal ng Office of the Vice President sa regional level ng COA, sa commission proper ng COA, at pwede pang humantong sa Supreme Court. The notices of disallowance does not presuppose guilt on the part of the Vice President. It is not tantamount to a prosecution. Kaya wag po natin itong gamitin, itong mga dokumento na ito, as if meron ng ginawang kamalian ang ating Vice Presidente. Dahil dito po pumapasok yung procedural due process kung ito pa'y accorded sa ating Vice Presidente. At isa pa po, yung pong mga ginawa ng Quadcom nung nakaraang taon, yung pong pagbubukas ng mga envelope, I don't think yan po ay kasama sa trabaho ng Kongreso. Dahil ang pag-audit po ay trabaho ng COA. So meron po tayong Latin legal maxim, potestas delegata non delegari. Delegated power should not be delegated further.
Reminded to confine the manifestation to the subject matter of the impeachment
Opo,
proceeding.
this is pertaining to the...
This is not
the
about
envelope.
Quadcom. This is the impeachment proceeding on the 2 complaints against the Vice President. Please stick to the subject matter of this impeachment proceeding.
But the envelope, yung opening of the envelopes, hindi po ba may kinalaman?
If you have concerns about the proceedings of Quadcom, perhaps you should address it in the other forums, but not in the impeachment proceedings. The Honorable Marcoleta is so reminded
Opo,
to stick to the subject matter.
Yun lang naman po, Madam Chair, notices of disallowance. Ito po ay hindi mga dokumento lamang na ito ay appealable, contestable, at hindi ito nangangahulugan ng Vice Presidente ay may ginawa ng irregular dahil ito ay contestable. Yun lamang po ang aking obserbasyon. At ma'am, if I may react dun sa earlier remark made by the chair, I think I was alluded to kasi nagkaroon po ng spectacle kahapon.
The chair just adopted the manifestation of the Honorable Marcoleta yesterday during our determination of form.
Opo, yung pong I am speaking out of premonition. Actually, I'm not speaking out of mere premonition. I was speaking out of experience.
But that's what the committee heard. Nevertheless, Honorable Marcoleta, this is likewise not a subject matter of this impeachment proceeding.
Opo, winawaringan ko lang po ang audience na to observe proper decorum. Wala naman po sigurong masama doon, Madam Chair, di po ba?
But of course, for as long as the public are not committing any offense inside this committee hearing, then there is no basis at all to call their attention or to even mention their name.
Okay, ma'am, pero nagkaroon po ng president kasi sa Senado. Salamat po.
Honorable De Lima, would you like to comment?
Very briefly lang po. Okay, the audit findings under the audit observation memorandum may be subject to appealable, and can still be questioned. But the fact remains that there are already evidence, there are already documentary evidence, kasama nga na po dito na naka-attach sa complaint, about those questionable disbursements, the use of confidential funds for not legal purposes for confidential intelligence funds. So this committee, since it's scrutinizing now the very complaint before us, has the discretion and has the duty and the prerogative to do its own scrutiny and analysis of these documents, irrespective of any final COA finding. Of course, it is ideal that we should have the COA final finding, but the preliminary findings are already the red flags. The preliminary findings already show those acts constitutive of impeachable offenses. So it's not really a hindrance to this committee not to consider first those preliminary findings pending the final finding of the COA.
Let us be reminded as well that impeachment proceeding is a sui generis proceeding. This is not a criminal proceeding, neither is this an administrative nor a civil proceeding. The Honorable Zamora.
Madam Chair, with all due respect to our colleagues here, I would like to remind everyone about where we are at the stage of our proceedings. We are discussing the sufficiency of, in substance of the impeachment complaints, and as such, Rule 3, Section 5 of the House Rules on Impeachment Proceedings state that the requirement of substance is met if there is a recital of facts constituting the offense charge and determinative of the jurisdiction of the committee. So we have to confine ourselves within the four corners of the complaint to check if there is a recital of facts which will show the nexus, as the Honorable Laila de Lima has repeatedly said, with the impeachable offenses charge. Thank you, Madam Chair.
Madam Chair.
Thank you. The Honorable Vice Chair Dumogan.
Thank you, Madam Chair. I was about to point out, we are in the determination of sufficiency in substance. And as far as ground number 1 is concerned, it had been supported by complete narration of facts and even documents.
Vice Chair, speak closer to the microphone, please.
Is completely supported by narration of facts as well as certified documents. So, as far as I am concerned, so that we give due process as being claimed, we answer it in the positive so that later on the respondent will be given the chance to explain. Because look, the confidential fund belongs to her office, and she can, with respect to the disallowance, it will be only her if she did appeal that one or she did not. Because as far as the records is concerned, this was a long time that it did happen, and when the disallowance was issued, we do not know of any appeal that had been done by the concerned respondent, Madam Chair. Thank you, Madam Chair.
Thank you. The Honorable Arbison. Kindly turn on.
Thank you, Madam Chair. I just want to make a manifestation regarding the definition of confidential fund.
Yes.
Confidential funds are lump sum budget allocation for government agency, specifically for surveillance, intelligence gathering, and security-related activities.
Yan naman ginawa.
These funds are designed for expenses that cannot be disclosed publicly to protect national security, peace, and order. Common use to include purchasing information, renting safe houses, and conducting undercover operation. Thank you, Madam Chair.
Thank you. Would you like to comment, Honorable De Lima?
No need, Madam Chair.
The Honorable Padiernos, and then Honorable Erice, and then Honorable Degamo. Honorable Padiernos.
Thank you, Madam Chair. Just wanted to make a few comments.
based on the observations of all of our committee members. So as mentioned by the Honorable
Padernos.
Zamora, at this stage, we are merely looking at if there is a recital of facts constituting the offense. So at this moment, we are not weighing evidence or proof. And we only determine whether, first, the allegations are more than mere conclusions of law. Number two, the impeachment complaints specify acts or omissions attributable to the respondent. And number three, the acts fall within the constitutional grounds for impeachment as provided for in our Constitution. So yun po yung betrayal of public trust, treason, bribery, other high crimes, and so forth. So, just to ano lang po, for the consumption of our viewers, hindi pa po natin dinedetermine dito yung guilt ng ating impeachable officer. Hindi natin sinasabi na ginawa niya yon. In fact, parang ano po yan pag nag-file tayo ng isang complaint, criminal complaint before the prosecutor. So, we are here acting as prosecutors and checking if there is probable cause, in this case, to determine whether there is, at this moment, recital of facts constituting the offense charge. At sabi nga po ni Honorable Dumogan, mayroon pa pong opportunity ang ating impeachable officer to respond to this complaint. Hindi naman po na wala na po tayong due process, kumbaga. Bibigyan po siya ng pagkakataon to defend herself in this committee. Nevertheless, gusto ko lang pong mag-make an observation. So as to ground one, assuming the allegations as pleaded for threshold purposes, the complaint alleges large-scale misuse and conversion of confidential funds in a manner that, if true, would plausibly constitute betrayal of public trust. Of course, minention din po yung labels ng plunder, malversation, and graft, and corruption. Pero tandaan po natin, itong mga crimes na to, may mga elements po yan that is provided under the law, and especially for mga malversation which is under the RPC, may mga requirement po yan na dapat may bad faith or criminal intent versus yung plunder, which is a special law, mala prohibita po, criminal intent is not required. So what I'm trying to say is, insofar as the crimes that were alleged, medyo sabi nga po ni Honorable Rodriguez, medyo upon perusal of the complaint, borderline po yan. Hindi natin pwedeng sabihin na pwede pong impeachable offense. Pero under betrayal of public trust, which is a catch-all phrase as given by under our jurisprudence, pwede po natin sabihin pasok Pero again, we are not we're not saying here that the impeachable officer committed betrayal of public trust. We're just determining now if kapag nalaman po natin na ginawa niya to, does it constitute that impeachable offense? So yun lang po, Madam Chair. Thank you.
Thank you. If there are, would you like to comment, Honorable De Lima?
Briefly, Madam Chair.
Yes, please.
Okay. Earlier, it was mentioned that we're acting here as prosecutors to determine probable cause. Not at this stage.
Yes.
Because at this stage, it's only the sufficiency of substance.
That's
Sufficiency in substance of the complaint. Now, about the fact or the observation that some of the grounds, including graft and corruption and plunder, may not, as alleged, the facts as alleged, may not fall under those, but definitely would fall under betrayal of public funds. It's betrayal of public trust. Now, it should be shown by the pieces of evidence that will be presented in proper time, that taken together, cumulatively, collectively, this can fall under those offenses or under those criminal acts of plunder and graft and malversation. As I mentioned earlier, when we talk about plunder, it's a series of acts of malversation of public funds. So we will see in the course of the evidentiary hearing that taken together, yung mga maglalabas po sa mga documentary evidence, most of them are here already, and also to be backed up by testimonial evidence, would show that the elements under those acts, plunder, malversation, graft, and corruption, will be sufficiently established. So evidentiary, Madam Chair.
Thank you. The chair believes that we had ample discussion already of the first ground. So with the indulgence of the members, we will be proceeding to our determination or deliberation on the second ground. Let me read. The second ground,
Can I reply to?
Honorable Suntay.
Yes, can I make
This is just a determination of sufficiency in substance. Would you like to reserve your opportunity to the succeeding grounds?
Madam Chair, before proceeding, just some additional points.
Because this is your first time for this first ground. Yes, you are recognized.
I just wanted to be clear that the signing of disbursement vouchers documents are not ministerial. People actually go to jail for basically just signing disbursement documents. No? People who are in the Sandigan Bayan today for many other reasons, because they had signed disbursement financial documents. So saying that it is a ministerial is not an actual defense. No? But secondly, on the point that COA had issued AOMs and NDs and are basically appealable, this is correct. But also, the documents contained in the AOMs and the NDs, the notices of disallowances, are also the body of evidence which constitutes the basis for the proceedings that we have today. And it needs to be reiterated that impeachment proceedings operate separately, independently of administrative proceedings of the Commission on Audit. So the statement that AOMs and even NDs are essentially appealable cannot prevent impeachment proceedings to occur and proceed as it should. Very important din po yung sa usapin po ng confidential funds, yung pong nexus doon po sa confidentiality ng use, no? Nung po confidential funds at nabanggit na po, not just in this proceeding but in previous congressional proceedings, that ginamit po yung pong pondo para sa team building activities at iba pang mga bagay na hindi po pasok doon sa definisyon ng paggamit ng confidential funds. Yun po yung una. Pangalawa, even if we talk about an actual use of confidential funds, which is basically the rental of safe houses, supposedly to accommodate yung pong mga givers of confidential information, I think in the previous Congress's Committee on Good Government, led by Congressman Chua, it had been stated by COA that malaki po yung ginastos para sa rental po of safe houses. So I think in the records that we have, 16 million has been used for the rental of safe houses, and I think an assumption was made that in the course of 11 days, around 500,000 was used for this. So if you make an extrapolation on a day-to-day, it would be around 45,000 per day. And if you further make an extrapolation to 30 days, that should be around 1.36 million per month in rental of these particular safe house properties. And the question therefore, and we will reach that point when evidence is elicited on what types of rental properties were used, saan po yung mga safe houses na ito? Kasi if you're talking about 1.3 million a month in rental property, saan po yung mga 1.3 million po natin makikita sa mga nagpapaupa? These safe houses
should be in Forbes Park. These safe houses should be in Dasmariñas Village. These safe houses should be in the most expensive condominiums in Bonifacio Global City. Pag wala ho yun doon, mga kaibigan, parang hindi ho tama rin yung pong sinasabing paggamit ng confidential funds, even if pasok po ito sa supposed tamang paggamit ng confidential funds, which is sa pagrenta po ng safe houses. Yun lamang po, Madam Chair.
Madam Chair.
Thank you. I apologize, Honorable Erice. I overlook your name here, Honorable Erice, and then Honorable Degamo, and then
Madam
we will
Chair.
proceed to the second round.
Madam Chair.
You're recognized.
Madam Chair, can I be given also a time to explain?
Honorable Abante after Honorable Degamo. Honorable Erice first.
Madam Chair, thank you. Maliwanag naman po na dito po ay dinedetermine lang natin yung sufficiency in substance. At maliwanag din naman po yung parameters sa pagdetermine ito, yun pong recital of facts with its nexus to an impeachable offense. Tingin po na-establish naman po ito at it would be prudent on the part of the committee kung yung presentation of evidences, yung mga opinions natin ay re-reserve na lang natin after na masagot yung ng kinocomplain nating tao, ng kinocomplain ng tao, upang sa ganun maging fair naman tayo. Di ba? So we cannot just say na 1.3 million Forbes Park, hindi pa naman natin nakikita yung kanyang explanation. Ang ngayon po, simple lang. Sufficiency in substance. Meron naman pong recital of facts. At ito po ay konektado sa isang impeachable offense. Kaya po, siguro, we should limit that to the discussion para po maging patas. Salamat po.
Thank you. Next is Honorable Degamo.
Yes po. Madam Chair, after hearing what have been said by Kong Leila about COA findings of irregularities, mismatch between declared purpose and actual expense, testimony from staff about cash withdrawals or distribution, evidence of lack of liquidation, direct approval of the VP. These are all linked, as have been discussed, to betrayal of public trust and graft. But then we have to remember that money trails are objective and they leave records. Kaya nararapat po siya na ma-discuss further. And para po kung talagang makikita, as what Kong Padiernos have said, kung talagang makikita na merong katibayan at talagang proof, then kahit sino pa po ito, it does not necessarily mean the VP. It could be anyone na gumawa ng mga ganito at napatunayan, mananagot po talaga. So I believe there is sufficient in substance po ang ating first misuse of confidential fund. At the same time, the VP will be given the chance to defend herself, maklear niya kung may mga pagkakamali sa mga allegations na ito. Salamat po.
For the guidance of the members, we're still on the deliberation of the first round. So for the last Kong to manifest, the Honorable Abante. After this, we will proceed to the second round.
I just heard, Madam Chair, my dear colleague, the statement outlining the definition of the confidential fund. I would like to remind my colleagues that tulad po ng sinasabi that public office as public trust. Ano po? I also would like to remind everyone that public money is also a public trust. So, ibig sabihin yan, confidential funds are not exempt from accountability. Oo, di ba? Confidential funds are not free money just to be spent by any impeachable official any way he wants. what she wants. They are still public funds, subject to law, subject to audit rules, and accountability. I'd like to remind everyone that we are not trying to determine criminal liability here. We're not the court. We are an impeachment agency here. So when a high official uses public office to subvert the public interest or to place personal or partisan ends above constitutional duty, impeachment is the appropriate constitutional remedy. Yun lang po ang gusto kong sabihin, Madam Chair.
Thank you. So with the indulgence of the members, that concludes our deliberation on the first ground. We are now proceeding to the second ground. Please allow the chair to read. Vice President Duterte committed culpable violation of the Constitution and betrayed the public trust by committing plunder and or malversation, graft and corruption and other high crimes in amassing and converting the amount of not less than 112,500,000 pesos from the confidential funds allocated to the Department of Education for the year 2023. Honorable De Lima, your manifestation.
Thank you, Madam Chair. For the second ground, it focuses specifically on the Department of Education's confidential funds. Katulad po nung kanina sa presentation on the first ground, ay ilalahad muna ho namin, papakita muna namin yung mga certain factual averments in relation to ground 2 before I make a discussion on why they are impeachable offenses. So ang kwento po, ang nakalagay po sa complaint, nabigyan ng 150 million na confidential funds ang DepEd. Hindi ito pangkaraniwang alokasyon para sa ahensyang ang mandato ay edukasyon, hindi intelligence gathering. Ayon sa mga alegasyon, ginamit ang kaparehong pamamaraan ng paggamit sa OVP. Tulad ng pagsacertify na ang confidential funds ay ginamit umano sa mga kailangan at legal na layunin. That's paragraph 76, annexes Rs and series. Inaprubahan at sinumite ang accomplishment reports na nag-a-itemize ng supposed expenditures. That's paragraph 76, annexes S series. At yung personal na mag-certify ng mga liquidation reports. Subalit nagpalabas ang COA Intelligence and Confidential Funds Audit Office, yung ICFO, ng Audit Observation Memorandum, AOM, dahil sa kabiguang magsumiti ng wastong documentary evidence of payments alinsunod sa Joint Circular number 2015-01. So that is paragraph 78, Annex T. Bilang tugon, nagsumite ang DepEd ng certifications mula sa Philippine Army upang bigyan katwiran ang 15.540 million na ginamit umano sa Youth Leadership Summits. That's paragraph 7980. Pero mariin itong tinanggi ng Philippine Army. That's paragraph 81, annexes U and V series. Sa masusing pagsusuri, lumitaw ang seryosong irregularidad sa dokumentasyon, katulad din nung sa OVP confidential funds. So paragraph 85, and supported by annexes W to Z, mga payee na may hindi mabasa o kulang na pangalan, mga resibo na inilabas sa magkakaibang lugar sa loob ng isang araw ng isang disbursing officer, magkakaparehong sulat kamay o pirma na ginamit ng iba't ibang individual. Hindi bababa sa 43,249,800 ang ipinamahagi sa 677 katao, kung saan 405 sa kanila ay walang PSA birth or death records. That's paragraph 86. Isa sa kanila, si Alice Crescencio, ay paulit-ulit na nakatanggap ng pondo gamit ang iba't ibang pirma pangalan na lumitaw din sa mga resibo ng OVP. That's paragraph 86, annexes A, A at BB.
Sa Sunday.
Higit pang nakakabahala, nag-certify ang DepEd SDO Fajarda na personal niyang naipamahagi ang mga pondong ito sa iba't ibang lokalidad sa loob ng isang araw.
Puto
Isa lang araw. Isang pisikal na imposibilidad at kalaunan ay umamin na ang pondo ay inilabas sa pamamagitan ni Colonel Nolasco. So si Colonel Nolasco na naman po ito ay umano'y ayon sa utos na VP. That's paragraph 88. So, given those essential facts, ultimate facts, and mas detalyado po yung nakita ninyo sa screen, if admitted as true, these pleaded facts under the second ground constitute diversion of appropriated funds, simulated liquidation, misuse of confidential funds, and betrayal of public trust. That satisfies sufficiency and substance for the second ground. Itahi ko po muli doon sa mga grounds. Yung culpable violation of the Constitution, graft and corruption, other high crimes and betrayal of public trust. These are the constitutional offenses alleged under this second ground. On culpable violation of the Constitution, kung ipagpapalagay na totoo ang paggamit ng confidential funds lampas sa mandato ng batas, kalakip ang umano'y peking dokumentasyon, simulated liquidation at pag-iwas sa COA accountability mechanisms, isang malinaw na modus ay hindi simpleng administrative lapse. Ito ay sinasadya at may kamalayang paglabag sa fiduciary duty na itinatadhana ng Article 11, Section 1 ng Konstitusyon. Ang public office ay public trust. Under the same standard applied in ground 1, culpable violation is sufficiently pleaded. How about graft and corruption? Tulad din po ng nabanggit kanina sa ground 1, ang paggamit ng pondo ay paraang taliwas sa mandato ng batas, ang mga peking dokumentasyon, hindi makatotohanang detalye sa paggamit ng pondo, at ang pag-iwas sa mga mekanismo ng accountability kung mapapatunayang totoo, ay malinaw na paglabag sa batas ukol sa tamang paggamit ng pera ng bayan. That is graft and corruption. This sufficiently invokes graft and corruption. Other high crimes. Sabi ko nga po kanina, ang other high crimes ay tumutukoy sa mga gawaing may matinding epekto na maayos na paggana ng pamahalaan. Ang sistematikong paggamit ng modus na ito ay nagpapakita ng pattern ng pagbaliwala sa batas na sumisira sa tiwala sa mataas na katungkulan. Ang ganitong asal ay isang act that renders a public official unworthy to remain in office. My position, Madam Chair, is that such conduct falls within other high crimes. And now, betrayal of public trust. Malinaw po na ang pagwawaldas sa confidential funds ay napakalaking kasalanan sa taong bayan na pinanggagalingan ng kaban ng bayan. Kung matunayan na ang pinuno ng isang ahensya ay involved sa modus na ito, malinaw na pagwawalang bahala ito sa tungkulin na gamitin ng tapat ang pera ng bayan. Ang ganitong paglabag sa tiwala ng publiko ay nagpapakita na hindi na siya karapat-dapat manatili sa katungkulan. So again, the second ground sufficiently meets the requirement of sufficient in substance, given those narration of facts na inugnay ko nga po doon sa mga constitutional offenses supposedly committed. Thank you.
To start our deliberation, we recognize the Honorable Rodriguez.
Thank you, Madam Chairman. Ground number 2 is totally outside the jurisdiction of this impeachment court. Section 2 of Article 11 enumerates the officials that will be impeached. I cannot see here the Secretary of DepEd to be impeached. In other words, Madam Chair, these allegations about actuations of Vice President Sara as a duly appointed Secretary of Education is not within the jurisdiction of an impeachment court. We're not impeaching here a Secretary of Education. In fact, Madam Chair, it is very clear that the once we are able to see there are some grounds of the Vice President to be able to be tried in the Senate, it is only removal from office of the Vice President and perpetual disqualification. In the case of the second ground, specifically, it talks about actions of the confidential funds in the Department of Education. Madam Chair, the Executive Order 292 of the late President Cory Aquino under his legislative powers in 1987 provides that the office of the Vice President is totally different from the office of the Secretary of a department. We have here, very clear, I have here, you can see here, Book 2, Distribution of Powers of Government. What does it say? Here, executive, exercise of executive power, the President. It is vested in the President. And Section 12, the Vice President also shall have the same qualification and so forth of the President, and he will be, it is he here, but it should be genders equal, may be removed from office in the same manner as the President. So this is under Book 2, Chapter 3. Now, we go to the Secretary of Education. Where is he found? It is on Book 4. Book 4 provides for the executive branch. The departments, it says here, Section 1, the executive branch shall have departments as are necessary for the functional distribution of the work of the President for the performance of function. Section 3, department proper. The department is run by the Secretary. Madam Chair, all of this will show that there is a dichotomy, a separation of the Vice President. When he was appointed without need of confirmation, then that is another duty of hers. And we are not here going to try the Vice President as Secretary of Education. We are only here to try his actuations in the office of the Vice President, wherein removal in case of impeachment could be ruled by the Senate. And therefore, Madam Chair, clearly, according to our rules which says determination of substance is met when there's a recital of facts constituting the offense charge, and there is an and here, and determinative of the jurisdiction of the committee. Determinative of the jurisdiction. What is jurisdiction of our committee? Impeachment is an impeachment now committee to impeach. The charges are to impeach the Vice President as provided by our Constitution. So therefore, not only is there a lack of recital of the facts, what is important here is that this round 2 is not determinative of the jurisdiction. So everything here, from 2 up to 6, which pertains to the Secretary of Education, should be ousted and dismissed immediately for being not within the jurisdiction of this committee. Thank you, Madam Chair.
The Chair wishes to raise a question to the Honorable Rodriguez.
Madam Chair.
This is for the sake of expounding our exchanges of argument. Honorable Rodriguez, does the Vice President cease from becoming such the moment she assumes the position of Secretary of Education?
Madam Chair, she does not cease, but then she holds another office separate from the office of the Vice President. And the Constitution is clear. In fact, it's only the President, Vice President, the Supreme Court. In fact, the very purpose of impeachment is to remove these high officials. In fact, the Secretary of Education, she resigned already. How can we proceed with hearing allegations on the Secretary of Education.
Madam Chair.
No, no, Chair. So therefore, yes, let's hear also our distinguished Chairman Benny Abante.
Is this in line with the
Yes.
argument of
Madam
the
Chair.
Honorable Rodriguez?
Perhaps with due respect to my good friend, Congressman Rufus, no, perhaps I could be able to correct the impression here. This committee is not to impeach the Vice President. It is to hear the impeachment complaint against the Vice President. This is not to impeach. This committee is not to impeach. Gusto ko pong i-correct yan sapagkat sabihin ng taong bayan na tayo rito, nagkakaisang impeach na ang Vice President. This is to hear the impeachment complaint, Madam Chair.
At this juncture, we are calling the Honorable De Lima for her comment to the manifestation of the Honorable Rodriguez.
Thank you, Madam Chair. I respectfully disagree with the main contention that the alleged acts attributed to the Vice President concurrently holding the DepEd portfolio cannot be taken cognizance of by this committee. Clear po, concurrently, in concurrent capacity. So kaya nga po, there was the bypassing of CA confirmation precisely because she is a Vice President. No need to go through the confirmation by the CA. We're talking here as one person, same person, si VP Sara, as both the Vice President and the DepEd Secretary. And we can also say that this is also part of the pattern, the scheme in those that we allege, the complainants allege to be attributable to the VP is also attributable to her in her concurrent capacity as DepEd Secretary because nga, nandyan yung modus, is the same modus. So we cannot separate the personalities of VPs of Sara Duterte as VP and also as concurrent capacity in those years that she was DepEd Secretary. Because nga, concurrent nga, we are talking here about same person. And we need to look into what is clear to be modus, the scheme, the pattern of her irregular acts constitutive of impeachable offenses.
Thank you. Any other member? The Honorable Suntay.
Thank you, Madam Chair. I completely agree with my distinguished colleague, Congressman Rufus Rodriguez. Constitution is very clear in its enumeration of impeachable officers. The Secretary of Education is not one of them. The actions of the Vice President as the Vice President of the Philippines is separate and distinct from her actions as Secretary of Education. But assuming for any stretch of imagination that we find the thing one and the same, the complaint alleges the exchange of money exchanging hands, but it does not allege any wrongdoing or illegal act. Kasi yung narration, sinabi lang, napunta, binigay dito. But that's the very nature of confidential funds. It's money changing hands, being distributed. And in all those narrations, we cannot simply assume
Suntay,
na,
sakto yung pangalan mo.
and simply conclude that the funds was actually went to the Vice President and became for her for her enjoyment. So I think that is a conclusion kasi doon sa narration sinabi napunta kay whoever kung kani-kaninong mga tao. Kung kay VP directly at sinasabi natin siya nagpa-withdraw, bakit kailangan pa umikot yung pera kung siya sa kanya rin pupunta? There is nothing in the complaint that states that it was used illegally. What is present is a conclusion made that it was used illegally. We cannot simply say that it went to VP Sara for her personal gain. Thank you, Madam Chair.
Madam Chair.
The Honorable
Madam Chair.
Chua. Honorable Chua, and then Honorable Tino, and then Honorable Abante.
Thank you, Madam Chair. This time, Madam Chair, I beg to disagree with my esteemed professor and my mentor, the Honorable Rufus Rodriguez, who happens to be my ninong also.
Your seatmate also.
And my seatmate also, my favorite seatmate. You know, the reason why I am like this is because of what he taught from me, what I gathered from the wisdom of the Honorable Rufus. Anyway, let me read, Madam Chair, what the Constitution provides with respect to the Executive Department, Article 7, Section 3, second paragraph, which provides that the Vice President may be appointed as a member of the Cabinet. Such appointment requires no confirmation. Madam Chair, if you will read this provision, it is very clear the reason why the Vice President is holding the position, cabinet position of DepEd Secretary is because of her being elected as Vice President. And in fact, Madam Chair, the Vice President is the only cabinet member who does not need confirmation. Siya lang po nagkakaiba. Why? Because she owes it to the people for electing her as the Vice President. Yun po yung aking argumento dito. Now, bakit naman po siya? Bakit ko naman po sinasabi na dito meron pong substance? Why? Dito pong grounds number 2, makikita po natin ito sa paragraph 72 to 91 dito po sa impeachment complaint. Dito po, mababasa po natin dito, sabi po dito, ito po, kung babasahin po natin, sa paragraph 79, page 31, sabi po dito, DepEd submitted its reply to COA ICPAW AOM. In this reply, DepEd attached DEPs justifying its use of confidential fund. The most notable of these DPS were certification issued by officials of the Philippine Army. So ano po ba to? Ito po yung certification na in-issue ng mga Philippine Army certifying, sinasabi po nila na wala po silang pondo na nakuha galing po sa DepEd contrary sa certificate na in-issue po nila dahil ito po ay hiningi ng DepEd. At kung babasahin din po natin yung paragraph 88, sinasabi po dito, Fajarda certified that he personally disbursed this amount to the different localities in a single day, a feat that is physically impossible. Fajarda later admitted that the disbursement were made through Colonel Nolasco, who was ostensibly a military aide assigned to OBP pursuant to instructions from the Vice President, Sara. Now, sino po itong si Fajarda? At sino rin po itong si Acosta? Now, we are talking here of two SDOs. Ang trabaho po ng SDOs, sila po ang Special Disbursing Officer. Meaning to say, sa kanila po yung pangangalaga ng pera. Sila dapat ang nagdi-disburse, sila rin po ang dapat na nagli-liquidate. Pero dito po, sa DepEd, dito po kay Fajarda, upon the instruction of the Vice President, or at that time, Secretary of DepEd, yung pera po, hindi po yung SDO ang nagdi-disburse. Dahil yung buong pera po, according dito po sa complaint, ay ibinigay po kay Colonel Nolasco na wala naman pong kinalaman sa pagdi-disburse po ng pondo. That Madam Chair, is betrayal of public trust, clearly. So, Madam Chair, I believe that we have sufficient in substance insofar as the grounds number 2 of the impeachment complaint is concerned.
Thank you, Honorable Chua. Next is the Honorable Tino.
Well, thank you, Madam Chair. This is also a rejoinder to the comments made by the Honorable Rodriguez as well. No? So, I would agree with him that the actions of Secretary of the Department of Education will not fall under the jurisdiction of the Committee on Justice when it comes to matters of impeachment. Because, of course, the Secretary of Education is not an impeachable official. However, we're not talking about just an ordinary Secretary of Education, but the Vice President appointed concurrently as the Secretary of Education. No, and so it is what is the subject of impeachment are the actions of the Vice President in her capacity as the Secretary of Education. And so therefore, I would say that such actions of the Vice President as Secretary of Education are within the jurisdiction of the Committee on Justice. And I would go further to say that as far as the third complaint is concerned, there are sufficient factual allegations to support the ground of betrayal of public trust and graft and corruption, Madam Chair.
Next is the Honorable Abante. This is on the argument of the Honorable Rodriguez that as Secretary of Department of Education, it takes away the offense outside the jurisdiction of the Justice Committee. That is the argument of the Honorable Rodriguez.
Yes, Madam Chair. Natutuwa lang ako sa binanggit ni Congressman Suntay na palaging sinusuportahan ko yan pag-eleksyon. At kahit na ganyan siya, susuportahan ko pa rin yan sa eleksyon. Pero ito po nga sabihin ko sinasabi nila, sabi si Congressman Rufus, talagang makaibigan kami yan eh. Nasabi po nila na distinct, di ba? Hindi pwedeng akusahan si Vice President doon sa nagastos niya sa pagiging Secretary of Education Department. Well, mabibigyan na lang po ako ng ilustrasyon. Logic lang po ito. Yung dalawang kamay natin. For example, ito yung Vice President. Ito yung Secretary of Education. Ito yung perang binigay ng Secretary of Education na kasama ring kamay ng Vice President. Ang tanong ko ito, sino ba nag-iisip? Isa lang ang utak eh. Wala namang utak yung isang kamay. Sa isang kamay. Isang utak lang po ang nagpapagana rito. Yun ang pong sabihin.
I hope everybody heard the analogy. Now it's the turn of the endorser to comment to the argument that the fact that the offense was committed as Secretary of Education, it takes away the offense outside the jurisdiction of the Justice Committee. The comment of the endorser, Honorable De Lima.
Being in a concurrent capacity does not segregate one from the other. And as mentioned earlier, under the Constitution, she's the only, official in the cabinet that to hold a simultaneous position. So the VP may be appointed as a member of the cabinet, and that's why hindi nga po kailangan ang confirmation. Now, doon naman po sa sinasabing iba ang sa DepEd, iba yung sa VP. Yung sa culpable violation of the Constitution, it does not say in relation to the proper office, whether office of the VP. It does not relate that it does not relate or is not in the relation to the office proper, which is the office of the VP as VP. That is the office proper of Sara Duterte as VP. It's attached to the person, yung pagko-commit ng culpable violation of the Constitution and even betrayal of public trust, it is attached to the person and position of the impeachable officer as her acts or omissions relate to the provisions of the Constitution. So hindi dapat nagiging stricto yung pag-delineate o pag-segregate, paghihiwalay ng mga alleged acts or omissions ng isang secretary, ng isang DepEd secretary who is at the same time the VP. Because these acts or omissions, yung nandun sa detalye po, underground 2, are her acts. One person as Vice President and DepEd Secretary in concurrent capacity. Hindi ho pwedeng gano'n na kung ano lang ang ginawa bilang VP, hindi yung as DepEd Secretary, even if these are related in terms of modus, in terms of pattern, in terms of system, ay hindi na dapat cognizable by an impeachment proceeding before the House Committee. Di ho ba?
You would like to
Respond
reply?
to reply to all those who said that we have jurisdiction.
All right, because of the significance of this argument, let's give an opportunity to Honorable Rodriguez to reply, and then for the endorser to manifest her rejoinder.
Thank you, Madam Chair. The jurisdiction of this committee acting as an impeachment committee springs from Article 11, Section 2 of the Constitution, and then Section 3 to Section to Paragraph 7 in seriatim. And clearly, it is only the actions of the Vice President. It is the only President, the Vice President, and then we have the Supreme Court and the others. So this is the distinction between them, is that there are two separate offices with two separate budgets. We determine the budget in Congress of the Vice President, and we determine also the budget of the Department of Education. So very clear that whatever stated here in ground 2 is it is not one of those that we will be discussing, because after all, in paragraph 3.7, the judgment of the case, we bring this up to the Senate, is it shall not, judgment in impeachment shall not extend further than removal from office. We cannot state in the decision, in our findings, that she committed violations as Secretary of Education. That is a matter if cases had been filed in the Ombudsman. Because the Vice President is not immune from suit. Although there's a question of whether the Ombudsman can suspend or dismiss a Vice President, because impeachable officials can only be removed through impeachment. That is another issue. But the point is that this impeachment court should only focus, because of the Constitution and our rules, that it should be we should have jurisdiction. It should be very clear that all these actions of the Vice President falls within, and if there's a recital of facts against the Vice President, which is sufficient in substance, it proceeds. But in this very particular ground, we are ousted of jurisdiction in this case, totally devoid of jurisdiction to be ruling on what the Secretary of Justice, Secretary of Education has done. In fact, she's already resigned. She's not anymore Secretary of DepEd. So that is what this representation has studied. We have to follow the Constitution. We have to follow our rules. Thank you,
Madam Chair,
To conclude our deliberation on the second ground, we will hear the rejoinder argument of the endorser against the argument raised by the Honorable Rodriguez. Honorable De Lima.
To me, Madam Chair, it is absurd to isolate acts or omissions committed by an officer, an impeachable officer, done in a concurrent official status or official public function, which is an adjunct or related to VP as VP. Otherwise, I can just commit violations, I can just commit offenses and skirt accountability. That simply because that's not really the office of the VP, but the office of the DepEd Secretary, but adjunct to her capacity or status as VP. I-skirt yung mga mai-skirt, will play around the law just so she will be absolved from the issue of impeachment or the possibility of impeachment, because these are related. It's the same person. It's also about fitness to hold office. Kasama rin po dyan, fitness, both as a VP and concurrent DepEd Secretary. Evil sought to be avoided and suppressed in impeachment principle applies to her as DepEd, the so-called mischief rule. She cannot avoid accountability when that very position as DepEd Secretary is attached or adjunct to her function or position as VP. Thank you.
just a quick manifestation. Maiksing-maiksi lang po.
That rejoinder of the endorser is supposed to conclude our deliberation on the second round.
Madam
Please
Chair,
reserve your...
I believe that my manifestation is very important. If we will follow the logic of my very good professor and dean.
Okay. So in the interest of equality and fairness, we recognize the Honorable Chua.
Kung sasakyan po natin yung argumento ni Congressman Rufus Rodriguez, at ngayon po, meron pong kaso sa Office of the Ombudsman ang BP. Paano po bang may lumabas na warrant? Pwede po bang damputin ng Vice Presidente at sasabihin siya inaaresto bilang Secretary of DepEd, hindi bilang Vice President? We cannot separate the Vice President from her previous position as Secretary. Why? Because we are trading a fine line. Pwede po itong maabuso. At pwede po itong magamit sa Vice Presidente bukas makalawa, maglabas ng warrant. Dahil po sa kaso niya ng pending sa Office of the Ombudsman. At sasabihin, kinakasuhan siya at pinoposasan. Dahil siya po ay Secretary ng DepEd, hindi bilang Vice President ng Republika ng Pilipinas. Yun lang po.
Thank you. So that
Madam Chair.
concludes our...
We have short manifestation in
Is that
interest of
in line
fairness.
also with the argument of Congress?
With the second ground. I
Yeah,
think it's
but is it
related.
in line with the argument of the Honorable Rodriguez
Ma'am,
about the jurisdiction of this committee over the offense committed as DepEd Secretary?
Madam Chair, let's not narrow the discussion. We're on ground 2, di ba ma'am? Nasa ground 2 po tayo ng impeachment.
All right.
So I can still
This
make
is
manifestation
a separate argument
for ground 2.
for the second round. The
Yes,
Honorable
ma'am.
Marcoleta is recognized.
Thank you, my favorite, Madam Chair. Favorite ko na po kayo. Ayan, ang sinasabi sa complaint ay may confidential funds na ginamit. At may money trail hanggang sa paglabas ng pera. But the narrative stops there. Dun sa military men. There is no mention that the money landed on the hands of the Vice President. Walang pinakitang ebidensya ng mga pondong ito ay ginamit sa illegal na pamamaraan. In fact, the same records mention that operational uses such as payment of safe houses, supplies, and other intelligence-related expenses were incurred. Wala namang binanggit na tinanggap ng Vice Presidente yung pera. Kung ganon, the mere movement or withdrawal of funds cannot automatically establish corruption, plunder, or any impeachable offense. Ang kailangan po ay malinaw na ebidensya ng ginamit na pera ay illegal, ay ginamit sa illegal na pamamaraan at hindi po ito binanggit sa complaint. At pangalawa po, Madam Chair, the complainants or endorsers of the complaint cannot simply reframe the alleged offense halfway through the process. Kung ang original na teorya ng complaint ay corruption or misuse of funds, hindi pwedeng kapag hindi iyon napatunayan ay bigla na lang itong ililipat sa betrayal of public trust para mag-fit sa anumang ebidensya na available. That would be fundamentally unfair. Hindi pwedeng baguhin ang ground for impeachment depende sa kung anong facts ang lalabas. Sa ganitong sitwasyon, hindi na ito simpleng fishing expedition, parang binabago na mismo ang impeachable offense para lang umangkop sa ebidensya na mayroon ang complainants. At kung papayagan natin iyon, nagiging unpredictable at arbitrary ang standard ng impeachment, which undermines the integrity of this process. Thank you, Madam Chair.
Comment from the endorser.
Thank you, Madam Chair. Betrayal of public trust is the ground. Betrayal of public trust, as mentioned earlier, encompasses the other grounds from the culpable violation of the Constitution up to other high crimes and even bribery and graft and corruption. So the Constitution is clear. It is a ground. So whether or not connected ito dun sa other impeachable offenses as alleged, it can stay on its own. It can stand on its own as a specific ground. So either encompassing the others or on its own. And for as long as the alleged facts really depict betrayal of public trust, then that is an impeachable offense. Yung katulad pong, doon naman po sa unang mga sinasabi na the judge should be proved later, that is evidentiary already, not at this stage of determination of sufficiency in substance. Thank you.
Thank you. That concludes our deliberation on the second round.
Madam Chair, one point.
This is my second attempt to
Sorry, but just one point.
shift to the third
Very
round.
short lang po.
With the indulgence of the members, this will be the last Justice Member we will be recognizing on the second round. You may proceed, Honorable Ridon.
Well, in the last two grounds, ulit-ulit po binabanggit yung wala daw pong personal benefit, no? Si Vice President Sara Duterte. That is something that will be shown at a future time. But again, to be clear, sa totoo lang, di naman ho kailangan ng personal benefit sa malversation. In fact, marami pong mga nasasakdal ngayon sa Sandigan Bayan. All they did was basically just sign into the disbursement vouchers, sign into the bidding documents. Nakapila ho sila doon ngayon, nakapiit ho sila sa mga kaso on malversation kahit sinasabi na wala ho silang personal benefit. So to insist na kailangan po ng personal benefit on impeachable offenses, parang mali po ata yun, Madam Chair. So again, to be clear, hindi ho required ang personal benefit sa malversation. Yung mere po na pagkakamali or maling paggamit ng pondo po na inilaan ay magkakonstitute na po agad ng malversation.
Madam Chair, just a reply because we have to consider the elements of malversation.
The Chair already pronounced that Honorable Ridon will be the last Justice Member to be recognized on the
Just to
second
clarify so that we
round.
don't confuse people. Personal benefit is an
Kindly
element
reserve
of
your
malversation.
manifestations for the succeeding rounds. Order, please.
Okay.
Now we proceed to the third round. The Chair will read, Vice President Duterte committed culpable violation of the Constitution and betrayed public trust by corrupting and bribing officials of the Department of Education. Let us now hear the manifestation of the endorser. Honorable De Lima.
Thank you, Madam Chair. So, the third ground is largely based on the statement of facts in relation to Vice President Sara's corruption and bribery of DepEd employees, which is covered by paragraphs 92 to 98, pages 34 to 40 of the complaint. Ang sinasabi po essentially, so ipapakita uli sa screen yung mga specific factual allegations in the complaint. But just to sort of sum it up, ito po ang kwento under this ground. Ito po yung allegation under this ground. Noong September 25, 2024, tumestigo sa Kamara si former DepEd Undersecretary and Head of Procuring Entity, Gloria Humamil Mercado. That's paragraph 92. Ayon sa kanya, mula February hanggang September 23, nakatanggap siya ng 9 na sobre na may label na Hope. Bawat isa ay may lamang 50,000. Karabihang umano ay personal binigay ni Assistant Secretary Sunshine Fajardo na nagsabing ang mga sobre ay direkta umanong nagmula kay VP Sara. Paragraph 93. Noong October 17, 2024, tumestigo rin si DepEd Director 4 at Back Chair Resty Osias na nakatanggap din siya ng 4 na sobre sa pagitan ng April at 4th quarter ng 2023. Bawat isa ay may lamang 12,000 hanggang 15,000 at dumaan din kay Fajarda. Paragraphs 95 to 96. Parehong pamamaraan o parehong modus. Noong November 5, 2024, tumestigo naman si DepEd Chief Accountant Runa Catalan na nakatanggap siya ng 9 na sobre na may tig 25,000 mula February hanggang December 2023 at tulad ng iba, itinaan kay Fajardo. That's paragraph 97. Ang pattern po dito, regular envelopes of cash allegedly originating from the Vice President coursed through a subordinate official. The complaint alleges, Madam Chair, if admitted as true, parte lang po ng mga allegations na yan under ground 3. I just chose the more important allegations. Madam Chair, if admitted as true, these allegations constitute bribery and corruption, which are expressly impeachable offenses under the Constitution. And ang nakasabi rin sa ground, is a third ground, it constitutes the constitutional offenses of culpable violation of the Constitution, betrayal of public trust, graft and corruption, and bribery. Yung mga acts na yon, ng pagbigay at pag-deliver ng mga envelopes to certain disbursing officers, special disbursing officers of the office ay bribery and corruption. Bakit naman po culpable violation of the Constitution? The constitutional oath requires faithful execution of the laws. Kung inaakusahang nanuhol sa kanyang mga tao ang isang cabinet-level official upang mapilitan silang baluktutin ang mga patakaran ng procurement o lumagda sa mga peking liquidation reports, hindi ito simpleng paglabag lamang sa isang batas, isa itong tahasang paglabag sa tamang proseso ng pamamahala ng pondo ng bayan. It reflects conscious and willful disregard of constitutional accountability. Para po sa akin, that satisfies the standard for culpable violation, a willful and knowing breach of constitutional duty. Bakit naman po betrayal of public trust? Kung ang panunuhol ay para maimpluwensyahan ang mga desisyon sa procurement at liquidation at ipagpapalagay na ito ay totoo, ang ganitong gawain ay sumisira sa integridad ng mga transaksyon ng pamahalaan, kumukompromiso sa mga internal control mechanisms, pagsusulong ng pansarili o pampolitikang interes bago ang integridad ng institusyon. That is the very essence of betrayal of public trust. At bakit naman po corruption and bribery? Malinaw po ito. The Constitution explicitly lists bribery, graft, and corruption as impeachable offenses, as grounds for impeachment. Sa ilalim ng Articles 210 at 211 ng Revised Penal Code at ng Republic Act No. 3019, the Anti-Graft and Corrupt Practices Act, sa pinakasimpleng paliwanag,
Ang bribery o panunuhol ay nagaganap kapag ang isang opisyal ng gobyerno ay nagbibigay, nag-aalok o nagpapadaan ng anumang regalo o benepisyo upang maimpluwensyahan ang isang opisyal na aksyon. That is in relation to the specific acts here. Samantala, sa ilalim ng Section 3, Paragraph A ng RA 3019, may parusa sa sinumang mag-udyok o mang-impluwensya sa ibang opisyal upang gumawa ng mga gawaing labag sa mga alintuntunin na may kaugnayan sa kanilang tungkulin. I submit, Madam Chair, the complaint pleads specific ultimate facts as to ground number 3. Hindi basta-basta ang mga paratang dito. Tinutukoy mismo ng mga ito kung letter A, paano binigay yung mga sobre na may lamang cash. So yun ang pagbigay, sobre na may lamang cash. B, sino ang tumanggap? Matataas na opisyal. C, magkano ang tinanggap? Mula 12,000 hanggang 50,000 each. D, para saan ibinigay? Upang maimpluwensyahan ang procurement at liquidation. Ano ang ugnayan ng pera sa mga opisyal? Tinutukoy po mismo kung ano ang ugnayan ng pera sa mga opisyal na gawain. Kung totoo ang mga alegasyong ito, malinaw nung tumutugma ang mga ito sa mga legal na elemento ng bribery at corruption. Pagbibigay ng pera, may kinalaman sa opisyal na tungkulin, may layuning impluwensyahan ang opisyal na aksyon. At this threshold, that is sufficient. I so submit, Madam Chair.
Thank you. Madam Chair.
Now we will hear the comments and manifestations of the members on the second ground of the third impeachment complaint. The Honorable Rodriguez, third ground.
Thank you, Madam Chair.
Third ground of the third impeachment complaint.
So once again, Madam Chair, under ground 3, the Committee of Justice acting as an impeachment prosecution is devoid of jurisdiction. The actuations of former Secretary Sara Duterte of the Department of Education is not within the jurisdiction and realm of an impeachment prosecution committee. Therefore, in this very, very clear case, there is allegation of culpable violation of the Constitution, and, this is not a ground for a Secretary of Education. These are grounds for the Vice President. Then, corruption, Republic Act 3019. It is a ground for the Vice President. It is a ground for filing in the Ombudsman under Section 3A or E of the Republic Act 3019, the Anti-Corrupt and Corrupt Practices Act. Then, bribing officials. Madam Chair, this will fall under Article 210 on direct bribery of the revised penal code, again, cognizable not by this committee, but also in the Ombudsman if they are minded to file this against the former Secretary of Education. Therefore, there is no substance, but it is devoid of jurisdiction of this honorable committee. I submit, Madam Chair.
Thank you. So for the guidance of the justice members, it appears that there is a similarity of argument of the Honorable Rodriguez with respect to the second and the third ground. That is of the third impeachment complaint. The Honorable Chua.
Thank you, Madam Chair. Also again, Madam Chair, I submit that my manifestation in the second ground is also the same in the third ground. Considering that what we are talking here is the Vice President in her capacity as Secretary of DepEd. Again, I would like to quote Section 3, Article 7 of the 1987 Constitution, second paragraph, which provides that the Vice President may be appointed as a member of the cabinet. Such appointment requires no confirmation. Again, the position of Secretary of DepEd is concurrent to her position as Vice President. And that is the only position, or that is the only cabinet secretary who needs no confirmation from the Commission on Appointment. And therefore, Madam Chair, I would like to submit again na imposible po talaga na paghiwalayin itong dalawa. Otherwise, baka po may mga abuso po sa ganitong logic at sampahan po ang hindi lang po ang ating Vice Presidente, yung mga susunod pa pong Vice Presidente na ayaw pong nilang isubject sa impeachment sa tamang proseso, idadaan nila sa shortcut, kakasuhan sa ombudsman at lalabasan ng warrant at siya po ay poposasan hindi po bilang Vice Presidente kung hindi bilang miyembro ng kabinete. Again, thank you po.
Honorable Chua, would you like to raise a motion for the adoption of our discussion in the second round for the purpose of our deliberation
Yes, Madam
of the
Chair,
third
I
round?
move that we adopt the discussion insofar as the second round of the impeachment complaint, third impeachment complaint. So move, Madam Chair.
There is a motion to adopt the discussion in the second round of the third impeachment complaint for the purpose of our deliberation on the third ground of the same third impeachment complaint. Do I hear a second? The same has been seconded. Is there any objection? Hearing none, the motion is hereby approved. Would you like to raise new matters in relation to the third ground, aside from the issue of jurisdiction? Because our discussion on the second ground has been adopted already for the purpose of our deliberation of the third ground. For the guidance of the justice members, please make sure that in continuing our deliberation on the third ground, make sure that your manifestation pertains to new matters other than the issue of jurisdiction. The Honorable Suntay.
Thank you, Madam Chair. Well, once again, while the complaint has a narration of movement of funds, again, it is anchored on hearsay. As stated, sinabi, nanggaling daw kay VP Sara. Pero hindi si VP Sara yung nagbigay nung envelope. Pangalawa, the allegations that money were used to manipulate procurement, disbursement, and liquidation process to benefit VP Sara are based on mere conjectures. Bribery is a transactional crime. It involves a public official performing an official act in exchange for a gift or favor. It can be direct or indirect bribery. But nowhere in the complaint did it show any contracts to be influenced, any contractors to be given in exchange for the alleged envelope. So once again, we cannot just conclude that it is to influence procurement or liquidation without any facts. There was also an allegation of a draft under RA 3019 of giving. Now, how is this crime committed? It can be committed by officials acting alone to benefit themselves or others. Common modes include giving unwarranted benefits, entering into disadvantageous contracts, conflict of interest, requesting or receiving gifts. But nowhere in the complaint showed that the Vice President asked or benefited from any of this. Thank you very much, Madam Chair.
Honorable De Lima, would you like to respond?
Yes, Your Honor. There have been testimonies about the release, the distribution of the envelopes containing cash. And these are given and distributed to those holding procurement-related functions. Now, what is that all about? That is about influencing the decisions of these officials. And that is certainly bribery. That is certainly corruption. aside from the TSNs, nandyan yung mga video ng mga officers na yon na sinasabi nga na tumanggap sila ng mga envelopes. So there's a matter of proof that has been clearly alleged, clearly and sufficiently alleged. Kasi yung sinasabing ang mga video, galing ito sa testimony nila, yung mga admissions ng mga officers na yon ng DepEd. Admissions receiving payola. It can be considered as payola. Admission of Reyna Catalan, that he received payments. Ganon din yung admission ni Resty Osias, receiving payola, payments. Admission of SDO Gina Acosta on the encashment of check for CF. Admission of SDO Edward Fajardo, also on the disbursement or of the admission, the receipt of check for confidential funds. So ano pa ho ba ang hahanapin natin na mismo doon sa mga taong nakatanggap at yun ang posisyon nila, they are key people doon sa mga disbursements ay sa mga pag-procure ng supposed materials, whatever it is, the needs of the Department of Education. Ano po ba yon? Tama ho ba yon na nagbibigay ng pera sa mga subordinates na hindi naman yun yung mga sweldo nila, hindi naman yun benefits nila, hindi naman bonus yon. That is illegal. Thank you.
Before we proceed, the endorser made mention about videos. Can you please expound what videos you are referring to?
Those are supposedly the ones taken during the appearance of these officials.
And whose
before the
videos are
committee.
this?
From the
The videos of the inquiry conducted by the good government.
Yes.
And did
yes.
you include that in your exhibits or attachments of the impeachment complaint?
Not yet, Madam Chair. We
Not
can always
yet.
we can always ask because these form part
Who are
of
these
the official
people in the
records.
videos? Just for the record, who are these people in the videos?
Catalan, Acosta, Mercado.
And just for the record, Honorable De Lima, what are they doing or saying in the video?
Receiving the payola, that they received those envelopes from the Vice President.
Madam Chair, just a reply.
Madam Chair.
It is
Honorable
very clear in the
Sundai,
affidavit.
Is that a reply?
Yes,
All
Madam
right,
Chair.
you're recognized.
The video showed that they received envelopes, but it did not show in exchange for what. So what was being influenced? We cannot just conclude that it is for something. Walang pinagkaiba yan dito. Sometimes envelopes are given, but it doesn't mean we are being bribed. Thank you, Madam Chair.
All right, that is the reply of the Honorable Suntay. Let's hear the rejoinder of the Honorable De Lima.
It's about, these are admissions that they received something, that they received cash. And it cannot be for any lawful purpose or purposes because they are holding those positions. And it's a matter of evidence also. We can always ask them again na ano ba sa tingin nyo yung pagbigay ng mga pera na yan outside of supposedly, because it's not supposed to be part of the function of a head of office to be giving money which do not pertain to the lawful purposes related to the functions of these officers. It's basically a matter of evidence. And the TSNs, these are all part of the records of the hearings.
Madam Chair.
Is this in line with
Yes.
the matter raised by the Honorable Suntay?
Yes.
Yes. You're
Yes,
recognized.
Yes, Madam Chair. We are just into the determination of the recital of facts, determination of the substance. Wala pa po tayo dun sa hearing proper. Maybe later on, when the proper hearing comes sa Senate, dun po pwede po lahat yan, yung mga affirmative defense po pwede pong ilabas. Thank you
All
po.
right, the manifestation is noted. Now it's the turn of the Honorable Lord Ansuan.
Thank you, Madam Chair. For clarity and again for purposes of determining sufficiency and substance under our rules, may I request the Honorable Endorser to restate which specific ultimate facts in the third ground directly attribute the alleged acts of bribery and corruption to the respondent, and more importantly, how these acts rise to the constitutional level of culpable violation of the Constitution or betrayal of public trust under Article 11, Section 2.
Honorable De Lima.
Thank you, Madam Chair. The recital of facts, the ultimate facts are pleaded in the complaint itself, referring to those testimonies, the admissions of these officers na tumanggap sila ng mga sobre at karamihan umano ay personal na ibinigay ni Assistant Secretary Sunshine Fajardo na nagsabing ang mga sobre ay direkta umanong nagmula kay VP Sara. That is an act attributable to her. And then even outside of yung tungkol sa pag-prove kung ano yung mga purposes noon, that can be considered as bribery really. It's a bribe to accept cash gifts. This can be considered as cash gifts because it's not clear kung para sa anong purpose ito. It's clear in the admissions of these officers that it has something to do with yung kanilang pag-perform ng functions para ma-influence yung mga procurement ng mga bagay, ng mga equipment, ng mga materials sa office, sa Department of Education. And as again, DepEd Secretary is concurrent. So, culpable violation of the Constitution. You're not supposed to do that. Public office is a public trust. All public officers are supposed at all times to exercise decency, fidelity, loyalty to the Constitution. Tama ba na gano'n ang ginagawa ng isang head of office na nagbibigay ng mga ganyan na mga monetary matters, monetary things na hindi naman kasama doon sa mga dapat natatanggap ng mga empleyado, ng mga opisyal ng isang department. Thank you, Madam Chair.
Thank you. Any other manifestation? If there are no more manifestations, then
Well, actually, Madam
Honorable
Chair,
Redon?
I think the committee is ready to, as a copy of the committee proceedings then. Maybe we can play it so that we can be refreshed as to the testimonies that had been elicited from, who are these persons again? Mercado et al. Madam Chair.
Catalan.
If it is the pleasure of the endorser, I think the committee has copies of the videos. We can play it for the members to see, Madam Chair.
I understand that the video referred to by the endorser forms part of the hearings conducted by the Good Government Committee. That is during the 19th Congress, no? But I think we should give ample time to the committee secretariat to be able to prepare the video. Honorable Tino, would you like to say something?
Madam Chair, is the video part of annex to the complaint? Is it part of the complaint? Was it annexed? Because it cannot be introduced if it was not annexed as part of the complaint.
Their testimonies are part of the narration of facts. No, but although it's not
Is it
yet,
part of the annex?
not
Was
at
it
this
annexed to the
point.
complaint?
Not at this point.
So,
But that is,
if the endorser is interested to play that video of the committee, then perhaps the chair should hear a motion. Because it seems that everybody is not in agreement about playing that video, aside from the Honorable Suntay. Honorable Suntay, are you opposing the playing of the video?
Actually, okay lang sa akin. I just want us to abide by rules because under Rule 3, Section 5 of the impeachment rules, the committee determines sufficiency based on facts alleged in the complaint. And if we are going to show a video which was not part of the complaint file, then how can we introduce it?
Well, according
Yung
to
sa
the
akin lang gusto ko,
endorser,
we just follow the rules.
according
Yun
to
lang.
the endorser, the admissions or the testimonies of the DepEd officials who will be seen in the video or who were in the video were actually part of the allegations of facts.
Yes, that is correct, Madam Chair.
Madam Chair,
The Honorable Tino.
Madam Chair, since nandiyan na rin, mukhang available naman yung mga video at binanggit na kasama ito sa recitation of facts nung pangatlong ground na kinoconsider ngayon, which is bribery. The Vice President bribed certain DepEd officials. And apparently, meron ngang video nung DepEd official, Mercado, na umaamin na tumanggap siya ng bribe. So, baka mas maganda po ay makita na to.
Since the Honorable Suntay is not opposing, it appears that no one is opposing, then we will be suspending for a few minutes just to inquire with the Secretariat if they are ready to present the video. Ready ba kayo? The meeting is resumed. May I confirm from the endorser if she's pertaining to the video of Mercado, Osayas, and Catalan? May we confirm from the endorser, the Honorable De Lima? Mercado, Osayas, and Catalan?
Yes, Madam Chair.
Okay. The purpose of showing this video is to provide guidance to the justice members as we determine the sufficiency in substance of the third impeachment complaint. So, it seems that the Secretariat is ready. Kindly play the video of these three DepEd officials.
Okay, I understand, ma'am, Yusek, that you have a statement. Meron po kayong statement na sasabihin. You are now recognized.
Thank you, Mr. Chair. Before I start, I just want to say that this is a very difficult thing to do, and I apologize to my children who didn't like me to join this session, and also my colleagues who are my friends, but I have to read my statement. My name is Gloria Humamil Mercado, and I have dedicated over 40 years to public service in the government of the Philippines. In my last year with government, I served as the Undersecretary for Human Resource and Organizational Development of the Department of Education. I was appointed as DepEd Undersecretary by President Marcos, as recommended by Vice President Sara in 2022, and I assumed office in August of 2022 and February 2022. In February 2023, I was designated as the head of the procuring entity of DepEd. As one of the signatories of DepEd's checking account, alongside Undersecretary for Finance, Annalyn Sevilla, I signed checks related to all funds and recall that some of the checks that I signed amounted to 37,500,000 pesos. Between February 2023 to September 2023, I received a total of 9 envelopes labeled Hope. My concurrent position in DepEd during that time. These envelopes were handed to me mostly by Assistant Secretary Sunshine Fajarda, which she says came directly from Vice President Duterte. What she would typically say as she hands the envelope. It would appear that I received this envelope by virtue of my office as Hope. Attorney Fajarda is the wife of Edward Fajarda, who is the Special Disbursement Officer. Although the exact date evades recollection, sometimes during the course of my tenure with DepEd, a member of my staff informed me that an inquiry was made by one of our officers in the field that Mr. Fajarda had made inquiries about the bank accounts of several individuals and if divulging such information to him was permitted. My office confirmed that it was upon the instruction of the Office of the Secretary. Evidently, it would appear that regional directors and other employees in the field would also receive sums on top of the regular salaries. Sometimes in October 2023, as the likelihood of a bidding failure for DepEd computerization have become apparent, I was approached, by Attorney Monsayak, and he suggested in the presence of other officials who was with me that the bidders should just discuss among themselves. Mag-usap-usap na lang para hindi masayang yung pera ng 2023. I firmly asserted that the procurement must be implemented and conducted in strict adherence with the rules. Sometimes on the 3rd or 4th week of October, I was summoned by Zulaika Lopez, the Chief of Staff of the Vice President and Undersecretary of the OVP. I was informed that I should tender my resignation effective that day. I refused to resign and I insisted on departing from service through voluntary retirement. The timing of my meeting with Ms. Zulaika struck me as more than coincidental. It gave me the impression that my candid responses was the real reason behind the push to relieve me of my office. It was as if I had become an unwelcome obstacle, despite simply doing my job as Hope and Undersecretary of Human Resources of DepEd. Prior to my meeting with Ms. Zulaika, there were other undersecretaries and assistant secretaries who were summoned also and were also summoned, all of the same purpose of informing them that they should tender their resignation effective on the same day. I signed my affidavit.
Does the endorser confirm that this is one of the video?
Yes, Madam Chair.
All right. Are there any other videos? Because I understand there are 3 DepEd officials. This is Mercado.
Catalan and Osias.
Do we have videos of Catalan and Osias?
Yes. Is there? There. Not at the moment.
It will be played.
Yes.
Right from your allowance, from your regular budget, nakakatanggap po ba kayo ng envelope just like Yusek Mercado and Director Osias from ASEC Fajarda?
Yes, sir.
Magkakano?
Minimal amount lang po.
Which is how much po?
It's not even,
Magkano po?
it's 25,000.
25,000. How many times po?
9
Ilan?
times.
9 times. From what month up to what month? Let me guess, from February to September?
I think so, sir.
So, nung September po, tumigil na.
Yes, Your Honor.
Just like Yusek Mercado. Tama po ba?
Yes, Your Honor.
So, thank you po.
So, just kindly state, Madam Endorser, the person in the video, that is? The person in the video, I think that's Miss Catalan.
Catalan, yes, Mr. Madam.
Because you are the one in the video. Do you recall, Honorable Chua, the position of Miss Catalan?
Yes, Madam Chair.
What is her position in DepEd?
I think she is also connected with the bidding.
Bidding? Bidding
Yes,
process?
bidding, if I'm not mistaken.
All right, so
Madam Chair, she's the chief accountant.
Chief Accountant.
Sorry.
Now we will proceed to the last video. I suppose this is Osayas.
Madam Chair. Tanong lang po, would you also receive envelopes from Ms. Shine Paharda? Parang ikinuwento ni Yusek Mercado, envelope containing cash.
All right, Your Honor, Mr. Chair, no, I must be candid about this. I must say I did, but I didn't know because I was new in the department. I thought it was a practice of the department. I thought, the very first time I encountered that matter, sir, was sometime in April of 2023. I didn't know I was summoned to the office of Assassination, and then I was given an envelope, and it was later on I found out that there was money in it, but it was not because I was a BAP member or whatever yet, because I was not at that time.
At that last hearing, sabi ni Yusek Mercado, kung natatandaan ko, 9 envelopes yung natanggap niya amounting to 50,000 each. Sa inyo pong pagkakaalala, hanggang kailan kayo nakatanggap na envelope? Ilan?
It started April. I think it was until September of that year.
Up to September 2023?
Yes, sir. But if I recall it right, I was only summoned about 4 times to the office.
4 times?
Yes.
Up to September 2023?
Yes, sir.
So yung last quarter po, wala na kayo natanggap?
Wala na po.
So in other words, wala na kayong envelope na natanggap ng 4th quarter ng 2023. Tama po?
Yes, sir.
Mukhang sumakto Sa panahon na hindi na ginamit ng DepEd yung confidential fund for the last quarter nang pumuputok na issue ng confidential fund. Anyway, Mr. Osias, I think this was also mentioned by the BP na press conference na magkano po pala yung laman? Magkano po laman ng envelope?
I think it was something like between 12 to 15, sir. Hindi ko na matandaan yung laman talaga.
12 to 15,000?
Very minimal amount, yes, sir.
Attorney Osias admitted that he has received envelopes. I'm not saying it's wrong, no? It can be an appreciation thing or a love gift, whatever it might be. I don't think it's wrong. Pero if that is actually the habit of the secretary, to give envelopes to her people, I wonder if only Yusek Mercado or you receive envelope. Perhaps Yusek Mempin should also say something about that, or anybody here among the DepEd family. Because as I've said, when you receive an envelope, there was no thinking that there's anything wrong with that. Wala kaming inaiisip na masama yan. Just, you're under oath, just tell us about it. And thank you for telling us that.
Again, so for the record, the videos were shown for the guidance of the justice members in the determination of the sufficiency in substance.
Madam Chair.
Madam Chair,
Let us recognize first the endorser before we recognize the justice members.
I just wanted to put on record that Mr. Osias was the former chair of the Bids and Awards Committee.
That is noted, Honorable De Lima. Honorable Suntay?
Yeah, I just also want to put on record that, in fact, the video
That is noted, Honorable De Lima. Honorable
actually
Suntay?
supports my earlier statement. Not kagaya yung binigay kay the first one, Mercado. She allegedly received an envelope, not from the Vice President, but from someone, but she was not asked to do anything. While she was a member of the BAC, in fact, sinabi niya sa statement niya, there was a bidding, magfe-fail yung bidding, and it did not push through. So, ibig sabihin, it was not to influence her because the bidding did not push through dahil magfe-fail bidding nga eh. Secondly, Catalan said she was the chief accountant. Ang testimony niya was, yes, she got an envelope, she was a chief accountant, but she did not say that she was made to doctor any books. Now, Usayas, yung statement niya, he was not even a member of the BAC at the time. Yun yung statement niya. If we could play it again, then it was mean that if there was indeed money being given, envelopes being given, it was given randomly to people, not in exchange for anything. Because the video was very clear. Thank you, Madam Chair.
The Honorable Shua.
Thank you, Madam Chair. Madam Chair, if I remember it correctly, during the question and answer portion between this humble representation and Mercado, I even asked Yusek Mercado, saan po binibigay yung envelope? Yung po ay binibigay po sa mismong opisina ng secretary. I'm not yet finished. Let me finish first. Now, having said that, Madam Chair, ito naman po ay determination lamang tayo ng recital ng facts of the offense charge. Yung pong defense na sinasabi po ni Honorable Bong Suntay, pwede po yung ilabas pagdating po sa mismong hearing proper sa Senado. But in the meantime, we are at the point of determining the substance. Now, Madam Chair, insofar as the manifestation of Honorable Suntay a while ago, that this video are not included in the complaint. However, under our rules, Section 6, Rule 3, it provides that once we determine that there is sufficient in form and substance, we will request the respondent to submit their answer. Tama po ba? And then after 3 days, may reply. At po pwede po sa mga to mag-attach ng mga documentary evidence, additional evidence. In fact, even affidavit and counter affidavit. So we are not limited dito po sa mga naka-attach lamang dito. Ito po later on, pwede po yan once mga pleadings na nagpalitan na dito po. But for now, we should first determine if there is sufficiency in substance by just reading the facts if there is an offense charge. Ilan po, Madam Chair, short reply lang.
Honorable
Very, very
Suntay.
short. Yes, well, tama yung sinabi ni Rep. Joshua, and I'm happy that he read it from our rules. Ang sinabi niya, once there is a determination of sufficiency in form and substance, we could receive additional proof. Then, there is still no determination in sufficiency in substance at this point. So it's premature to introduce it now. Pero hindi naman ako nag-object eh. Hindi naman ako nag-object. Dahil actually maganda nga na pinakita natin yung video because it supports my earlier statement. Now, and lastly, yung akin naman, while I know ito, yung hearing natin na ngayon is in form, determination of form and substance lang. Itong mga tanong ko lang naman at observation is being brought out because I want us to use the same parameters na ginamit natin sa impeachment complaint kay President BBM, which andun din ako eh, and we did exactly the same thing. So I just want us to use the same parameters. Thank you, Madam Chair.
Thank you, Honorable Suntay. If there are no other members who wish to manifest on the third ground, do you have additional rejoinder on this, Honorable De Lima, for the third ground?
Just to
Before we shift to the fourth.
Just to emphasize the point that it's a matter, again, of defense. Those points, those arguments put forth by the Honorable Suntay, and talagang sufficiency in substance pa ito. And tama po, sinabi ni Honorable Congressman Chua, that we can still attach additional evidence sa mga pleadings na ipa-file in proper time if there has been a determination already that the complaint is sufficient in substance. Thank you.
We note the manifestation of the Honorable Endorser. That concludes our deliberation on the third ground. Now we are proceeding to the fourth ground. Please allow the chair to read. Vice President Duterte committed culpable violation of the Constitution, betrayed the public trust, and committed high crimes in contracting to murder or assassinate the President, the First Lady, and the former Speaker of the House. At this juncture, we shall hear the manifestation of the Honorable Endorser. Honorable De Lima.
Thank you, Madam Chair. So this is about the threats of assassination hurled by the Vice President, the second highest official of the land, directed at the President himself, the First Lady, and the House Speaker. Napakalinaw po nitong allegation na ito. Dahil nga po, nakita natin yung pagbigay ng threats na yan to assassinate those three officials or those three personalities. So, it was clearly alleged in the complaint na sa isang media briefing, sa isang viral video, hayagang sinabi ni VP Sara na nakipag-usap siya sa isang assassin at inutusan itong patayin si Pangulong Ferdinand Marcos Jr., the First Lady, and the former Speaker of the House. At sa halip na bawiin ang pahayag, kinumpirma pa niya na nakausap nga niya ang isang taong may kakayahang gawin ang kanyang pagbabanta. Kinumpirma niya yan sa isang media interview. So these are paragraphs 100 and paragraphs 105. The core ultimate fact alleged here, Madam Chair, is that instead of resorting to lawful remedies, she contracted an assassin, the Vice President contracted an assassin to kill the President, the First Lady, and the former Speaker, alleging conspiratorial violence against the highest officials of the land. Assuming these allegations are true, and how can that be disputed? There is a video, there are clippings, and there is a video duly authenticated by the NBI, which formed the basis actually of the filing of cases for inciting to sedition. So, klaro po ito na they constitute high crimes and betrayal of public trust of the gravest constitutional magnitude. So bakit culpable violation of the Constitution? Ang pakikipagsabwatan upang ipapatay ang Pangulo, ang unang ginang at ang dating Speaker ay hindi isang simpleng political rhetoric lang. Kung ipagpapalagay na totoo, ito ay hindi simpleng pagbabanta lamang. This is a willful breach of her duty. That is the very definition of willful constitutional betrayal. Kung sanay sila sa pagbabanta, sa pag-utos o pakikipagsabwatan, sa pagpatay ng tao, hindi ito dapat pinagsasawalang bahala. Dapat itong panagutin sa batas. VP Sara's oath of office is not ceremonial. It is a constitutional commitment to uphold lawful processes, maintain peace and order, and protect the stability of the Republic. At bakit naman po maituturing itong other high crimes? Ang other high crimes ay tumutukoy sa mga gawaing may mabigat na epekto sa maayos na pagpapatakbo ng pamahalaan. Kung totoo ang alegasyon ng sabuatan upang patayin ang mga pinakamataas na opisyal ng bansa, ito ay magdudulot ng kaguluhan sa constitutional succession, panganib sa pambansang seguridad at kawalang katatagan sa pamahalaan.
this is perhaps no clearer example of an offense that strikes at the orderly working of government. Even without a criminal conviction, such an allegation, if admitted, squarely falls within the constitutional concept of other high crimes. At bakit naman po betrayal of public trust? Kung totoo ng respondent ay nais gumamit ng dahas para patahimikin o mapatalsik ang mga leader ng pamahalaan, pagyurak ito sa kaayusang konstitusyonal. This is betrayal of public trust in its most severe form. Hindi na dapat manatili sa posisyon ang ganitong mag-isip. So, the allegations are clear. The evidence is there. The video is available. The video is of public knowledge. The fact of that threat of assassination has reached the level or the status of notoriety na maraming nakakita. Tayo, nakita natin yung video na yan, lantaran na nagbanta against the President, the First Lady, and the House Speaker. So malakas po ito, former House Speaker, malakas po itong ground na ito. And I suppose the video is ready to play. All right, so since our endorser is mentioning about the video, with the indulgence of the members, we will be suspending for the Secretariat to prepare for the presentation of the video.
Useless.
The meeting is resumed. The Secretariat is directed to play the video.
Sa security ko kasi may kinausap na ako na tao. Sinabi ko sa kanya, pag pinatay ako, patayin mo si BBM, si Lisa Caraneta, at si Martin Romales. No joke. No joke. Nagdilin na ako, ma'am. Pag namatay ako, sabi ko, huwag ka tumigil ha, hanggang hindi mo mapatay sila.
Killer.
And then he said yes. Huwag ka mag-alala, ma'am, sa security ko. Kasi may kinausap na ako na tao. Sinabi ko sa kanya.
So may we request the Honorable Endorser to confirm if that is the same video that she is referring to? Yes, Madam Chair. All right, so that is for the record. We showed the video for the guidance of the justice members in the determination of sufficiency in substance. Are the members who wish to comment or manifest with respect to the fourth ground of impeachment or in relation to the video just presented?
Madam Chair.
The Honorable Zamora.
We are all familiar with the actuations of the Vice President as seen in that video. That was in fact on November 23, 2024, and that took place after the Committee on Good Government had their proceedings, and well, we all knew what happened then. That was the time when Attorney Zulaika was detained. And well, it is incumbent upon us to point out the specific portions of the complaint. The Honorable Laila de Lima already mentioned, but it is clear here under paragraph 100 that the Vice President committed overt acts constituting impeachable offenses. It says here, and as we saw in the video, that on November 23, 2024, in a morning briefing with the media, Vice President Sara stated that she has talked to an assassin and had instructed him to kill President Marcos Jr., the First Lady, and the former Speaker of the House of Representatives. To continue in paragraph 105, it states here, instead of retracting what she said, Vice President Sara admittedly owned her previous statement. On November 26, 2024, she publicly confirmed that she had indeed talked to a person who could assassinate the President, the First Lady, and the former House of Representatives Speaker. A reporter said, "So, but you already talked to a person?" Vice President Sara said, "Yes." "To do that in the event that you are killed?" And Vice President Sara said, "Yes, yes, yes." It is my position that the threats were conditional, is inconsequential, and that the mere act of engaging an assassin, as stated in the complaint, is opposed to her oath, and that the mere act of uttering these statements is already impeachable because at the very least, it amounts to a betrayal of public trust, aside from all of the offenses charged in the impeachment complaint. Thank you, Madam Chair.
Thank you, Honorable Zamora.
Madam Chair.
Honorable Suntay.
Madam Chair, the complaint alleges that the respondent declared that she had arranged for a person to kill the President, the First Lady, and the Speaker if she herself were killed. The complaint alleges a public statement, but it does not allege the existence of an actual agreement to kill. There is not even an overt act in furtherance of such agreement. Any act constituting conspiracy or any act constituting conspiracy or attempted murder. Kasi yung alleged gunman, hindi man lang natin na-present. Now, let's go to the doctrine of free speech. Which guarantees free speech and free press do not permit the state to forbid or prescribe the advocacy of the use of force or of law violation, except where such advocacy is directed to inciting or producing imminent lawless action and is likely to incite or produce such action. Advocacy of violence or law-breaking is protected unless it is directed at inciting or producing imminent lawless action and is likely to produce such action. That was stated in Salonga versus Cruz Paño, 134 SCRA 438. Now, kung makikita rin natin dun sa statement ni, dun sa video, and I'm glad that it was flashed on screen, which, kasi, in fact, dapat nga hindi, because it would be premature. As I mentioned, the video is not part of the complaint, but okay lang na ipakita natin dyan because it brings back yung yung pag-aalala sa mga yan. The VP said that she hired someone to kill. If she herself was killed, lo and behold, they are both alive. So ibig sabihin, walang overt action which was done. You know, sometimes when I go home late, my wife always threatens to kill me. Sabi sa akin ng asawa ko, papatayin kita na eh. Umaga ka na naman umuwi. And you know, my wife is the queen of our home, and she is highly respected by everyone in our household. But you know, I am still alive, and my wife only kills me with love. Common sense dictates that if you are really serious in killing someone, you do not announce it to the whole world. Why would you announce that you will kill someone if you really intend to kill someone? Common sense dictates otherwise. Thank you, Madam Chair.
Madam Chair.
Thank you. Honorable Abante.
With due respect to Congressman Suntay, I do not know if he is lawyering with for the Vice President, because I would even think that he is right now defending her. Pero ito you have seen the video. Whether it be that he is joking, that's between her, diba? Thing is this, that amounts to a credible threat against the President, the First Lady, and the Speaker. That is not political noise. Just like what he's saying about his wife. What he's saying about his wife is only political noise.
No, but my wife
But that is not political noise, Madam Chair. That is a red flag for national stability and constitutional order. Why? The Vice President is not a private citizen. The wife of Congressman Sultay is a private citizen, but not the Vice President. The office of the Vice President carries access, influence, and security resources. That is why the standard for public trust is higher, not lower, Madam Chair. Thank you very much.
Madam Chair.
The Honorable Adjong.
Thank you, Madam Chair.
And then Honorable Degamo.
Very, very short manifestation regarding the video. The whole nation is aware of this video, actually, Madam Chair. It came out during a press conference that the Vice President called for when Attorney Zulaika was in detention in the House of Representatives. My take on that, Madam Chair, is you can argue on whether a crime is being consummated or not, because some say that it has not been fully implemented, and so therefore the crime is not committed itself. To me, Madam Chair, I know how a layman would understand that is, it does not take one particular threat to be consummated, meaning to be implemented, for it to constitute a betrayal of public trust. The mere fact, Madam Chair, that it was uttered by a sitting Vice President to threaten a sitting President and claim that she had contracted an assassin to do her bidding is in itself an impeachable act. It's in itself a betrayal of public trust, Madam Chair. So whether or not it was said in jest, whether or not there was an intention, because it's conditional according to some, whether there was not really an intention, except, for example, that she herself was killed. So that's irrelevant to me, Madam Chair, because the fact that it was said, the threat was said by an official who needs to uphold a high standard of the demand of her office should be upheld in such a high standard, would to me fall under the category of a betrayal of public trust.
Yes.
That is my humble submission, Mr. Chair, Madam Chair, on the issue of the video that just flashed, it's played on the monitor, Madam Chair, Your Honors. Thank you. Maraming salamat po.
Thank you, Honorable Adjong. At this juncture, we recognize the Honorable Degamo.
Yes, Madam Chair. I would like to speak from a personal experience. My husband, the late Governor Degamo, before he was murdered. By the way, we will be remembering his 3rd death anniversary tomorrow. That's March 4. He received threats before he was tragically murdered. The threats at first were conditional. Like, if you do this, something will happen. But then, even though they were conditional, the fear and intimidation they cause were very real. Conditional threats can turn into actual harm. Nangyari po yun sa amin. In the same way, when the VP reportedly made statements implying harm to the President, the First Lady, and the former Speaker, those statements are serious, even if phrased as conditional. Kasi words from someone in her position carry weight. It can intimidate other officials, it can influence decision, and even undermine public trust. That is why, in impeachment terms, such conditional threats are considered sufficient in substance. It's not just the wording that matters, it's the effect and potential for harm, especially when the speaker holds high office. Just as in my family's experience, conditional threats really must be taken seriously. Gusto ko lang pong idagdag. The legal connection there talks about a threat does not have to be absolute or immediate to be serious. What matters is its potential impact, especially if the speaker holds power. Conditional threats can intimidate or coerce. Even a statement that starts with "if" can pressure officials or institutions to act a certain way. And high office makes it more serious. Maybe words from ordinary people may be limited in effect, but threats from a person who is holding a national leadership post carry far-reaching consequences. Kaya nga po, public office demands higher standards of behavior. Yun yung nire-require sa atin. Dahil if wrongly handled, and I must admit, my husband must have wrongly handled the situation back then that resulted now to his 3rd year anniversary, still waiting for justice to be served. Yan lang po, Madam Chair. Thank you.
Thank you, Honorable Digamo. Next in line is Madam Endorser. Can we finish first the manifestations of the justice members before we go back to you?
Yes, Madam Chair.
The Honorable Chua.
Thank you, Madam Chair. Madam Chair, let me borrow the words of the late Justice Cruz, Justice Isagani Cruz, when he defined impeachment as a method of national inquest into the conduct of public men. Ang ibig sabihin po nito, ang tinitignan po dito ay yung mga taong nasa taas ng lipunan kung paano nila maglabas ng behavior sa publiko. Ang hinuhusgahan po dito sa impeachment ay yung kanila pong conduct. Obviously, napanood po natin, hindi po ito yung conduct na inaasahan po natin sa isang tao na may pangalawa sa pinakamataas na posisyon sa ating lipunan. Yung video po, ang tinatawag po natin, res ipsa loquitur. The video speaks for itself. Hindi na po natin kailangan magpahaba. Hindi po ito usapin ng kriminal para tignan po natin ang elemento ng threat. Ang tinitignan po dito po sa pinakita sa atin, yung conduct ba na pinakita niya ay binetray niya yung public trust? Ito ba yung conduct na inaasahan natin sa isang tao na mataas ang katungkulan sa lipunan? Pag sinagot po ninyo ko na ito po yung conduct, maaari ko pong sabihin na wala nga po talagang substance. That's all, Madam Chair.
Let us be reminded that in various discussions of impeachment process, we try to determine the fitness of the public official to hold public office. That is for the record. Any other member who wish to manifest? You would like to add, Honorable Digamo.
Yes, Madam Chair, and if I may add, itong grounds po na ito, we are not just dealing here with the VP, no? Ang ibig ko pong sabihin, kahit sino po, pwede naman pong ang source of threat is the President. Source of threat could be the Speaker, directed to the VP, the President, directed to the VP. Pwedeng it could be directed to any other public official. Pero yun po yung nakikita natin na hindi talaga dapat binabaliwala para wag naman pong matulad sa amin. So it's not about personalities. It is about the actuations na ginawa at dapat may managot. Thank you po.
Thank you. Next is the Honorable Vice Chair Dumogan.
Thank you, Madam Chair. I don't like to repeat what had already been said, but looking at the allegations in ground number 4, including the video that we had just watched, at the stage of determining sufficiency in form, it has already complied. Thank you, Madam Chair.
Thank you, Honorable Dumogan. We will now go back to the endorser of the impeachment complaint, the Honorable De Lima.
100 lang.
Thank you, Madam Chair. To just be brief, yes, res ipsa loquitur. The video says it all. Res ipsa, the thing speaks for itself. The video itself speaks for what we are alleging as impeachable offenses. No joke, no joke. Then there's no issue anymore as to whether it was meant to be a joke, because it's the VP herself who says, no joke, no joke. So wala na pong question dyan. Hindi na po natin kailangan i-prove na yun ay joke because it came from her,
That it is not a joke.
her own language. It's admission against interest. There is also no such thing as conditional threat. A threat is a threat. Irrespective of whether or not there is such a condition, katulad nung binanggit ng VP, na kung mamatay daw siya, it doesn't erase the fact that she made a threat. So there is no such thing as conditional threat. It's also a non-issue. Now, you saw also the video. It has been widely covered even by foreign media. What other country, or is there any other country where we have seen such an incident of the second highest official of the land, a very high official of the land, making such a very open and public and brazen act of threatening the president and the two others? So, malinaw po itong ground na ito. Isa po ito sa tingin ko ang pinaka-malakas na magiging basis ng impeachment. Thank you.
That concludes our deliberation on the fourth impeachment complaint. We shall now proceed to the fifth ground of the third impeachment complaint. Please allow the chair to read. Vice President Duterte committed culpable violation of the Constitution and betrayed public trust in amassing unexplained wealth and failing to disclose all her properties and interest in her SALN in violation of Section 17, Article 11 of the 1987 Philippine Constitution. We shall now hear the manifestation of the endorser. Honorable De Lima.
Thank you, Madam Chair. So there are allegations with respect, ultimate facts, essential facts, with respect to this fifth ground. Unexplained wealth and failure to disclose all her properties and interests in properties in her SALN. That is under paragraphs 107 to 109. When she served as Vice Mayor and Mayor of Davao City with an estimated annual salary of approximately 2 million. Her declared net worth increased from 13,877,469 in 2007 to 44,828,759 in 2017, paragraph 108. It is further alleged that between 2006 and 2015, she had at least 111 million deposited in various banks in Davao City and Metro Manila, with reports suggesting even higher amounts. So the complaint pleads Section 2 of Republic Act 1379, establishing that property manifestly out of proportion to lawful income is presumed prima facie and lawfully acquired. Under paragraph 286, the complaint cites the case of heirs of Ligot versus Republic, pleading the elements required for the presumption to apply, that though the properly manifesting out of proportion a property or assets that are manifestly out of proportion to lawful income is presumed prima facie and lawfully acquired. The complaint pleads that all elements are present. If admitted as true, these facts implicate SALN obligations under Section 17, Article 11 of the Constitution and constitute betrayal of public trust. In relation to this ground, we will be asking in proper time during the evidentiary hearings or even before the evidentiary hearings via subpoena for the production of the SALNs of the VP all through the years from her incumbency as Vice Mayor, Mayor, and VP. Also the bank accounts. The bank accounts are expected to show that over 2 billion pesos were transacted across joint accounts during her incumbency. Joint accounts with the father, with her husband, and the joint account of the Duterte family. Culpable violation of the Constitution. Kapag ipagpapalagay ang totoo ang mga alegasyong ito, ang mga ari-arian na hindi tugma at malayo sa legal na kita ng opisyal ay maituturing ng may presumption and unlawful acquisition. At kung ang mga ari-ariang ito ay hindi dineklara sa SALN, ito ay direktang paglabag sa Section 17, Article 11 ng Constitution. Ang SALN ay isang sinumpaang deklarasyon. On betrayal of public trust, ang SALN ang pangunahing instrumento kung saan sinusukat ang katapatan at pananagutan ng isang opisyal. An unexplained wealth, particularly when coupled with alleged non-disclosure in a sworn constitutional document, the SALN strikes directly at the integrity expected of high public office. It erodes confidence in the official's honesty. That is precisely the kind of conduct contemplated under betrayal of public trust. Thank you, Madam Chair.
Thank you. The Honorable Flores.
Madam Chair, may I know from the endorser if would these allegations not be in contravention with the Supreme Court resolution or decision in the case of Sara Duterte versus House of Representatives when it said that we should only be including allegations for impeachment for actions done while she is holding an impeachable office. From the statements kasi that were given, the silence she was referring to was in 2007 to 2017, way before the Vice President, she became Vice President. No? Secondly po, na-mention din po ng endorser nung bank deposits, but these were just allegations. No? Walang sinabi na may proof na may bank deposits of this and that. No? Ang worry ko po dito is this might be compared with the previous how we handled the previous complaint against the President Bongbong Marcos that we dismissed it because it did not sufficiently have any substance because it was also purely speculations and allegations. May we hear from the endorser on this matter, Madam Chair?
Honorable De Lima.
Thank you, Madam Chair. Yes, it is true that in the Duterte versus House of Representatives case, the Supreme Court stated that the offenses to be impeachable must be committed during the incumbency of the impeachable official. We submit However, this does not mean that we cannot include acts that were committed prior to the incumbency of the official, here the Vice President. We can do that so long as we prove that, A, they are relevant to the charge that she also accumulated ill-gotten after she was elected as Vice President, based on Rule 128 of the Rules of Court, Sections 3 and 4. Evidence is admissible when it is relevant to the issue, as is not excluded by law of or these rules. They are offered to prove. They will be offered to prove a system, scheme, habit, custom, or usage, and the like, based on Rule 128 of the Rules of Court, Section 35. Evidence, it says, Section 35, similar acts as evidence. Evidence that one did or did not do a certain thing at a time is not admissible to prove that he or she did not or did not do the same or similar thing at another time. But it may be received to prove a specific intent or knowledge, identity, plan, system, scheme, habit, custom, or usage, and the like. And this is what we will prove during the evidentiary stage. That the Vice President accumulated even more ill-gotten wealth after she was elected as Vice President, and that accumulating ill-gotten wealth is part of her system, scheme, habit, or custom as a public official. Also, presentation of the SAL-Ns while she was still a mayor and vice mayor are relevant to show the contrast between her income and assets before and after she became Vice President. And again, we're talking here about fitness of the respondent to continue holding office as a public official. So hindi po yan, yes, there is that Supreme Court ruling, pero hindi po ibig sabihin na hindi na natin pwedeng i-consider. As I mentioned earlier po, we intend to apply for subpoena for the production of these SAL-Ns from her incumbency as mayor and vice mayor and all through her incumbency as vice president. Mga bank accounts din, ganun din po. We will ask for subpoena also from AMLAC, from the Office of the Ombudsman. And then para ho ma-prove, makita na yung pag-accumulate ng ill-gotten wealth which is grossly disproportionate to her lawful income ay nandyan, kasama yan sa kanyang pattern, kasama yan sa kanyang style or character as a public official. Again, we're talking here about fitness to remain in office as Vice President related to previous acts as well as something or things that are continuing. Makikita po natin yan dun sa mga ipapasabina ng mga dokumento as well as supported by testimonial evidence. Dati na rin po nag-testify noon former Senator Sonny Trillanes about the flow of these transactions. And again, those are part of the records of the Quadcom committee hearings that can be taken judicial notice that can be taken cognizance of as part of the House's records. So ito po ang explanation kung bakit pwede pa kahit ang nakasaad lang, nakasabi lang ay tungkol doon sa accumulation of ill-gotten wealth not truly reflected or properly reflected in the SAL-Ns nung siya ay mayor and vice mayor. Part of the issue of fitness of a public official.
Madam Chair.
Honorable De Lima, are you finished with your
Yes, ma'am. Yes, Madam Chair.
manifestation? The Honorable Flores.
Madam Chair, siguro for us to show na may connection po, shouldn't there be like allegations also that the SAL-N that she submitted while she was Vice President can be linked to the siguro disclosures in the SAL-Ns when she was Vice Mayor? Kasi you're saying that we should show pattern, scheme, or res inter sa acta ba yun na rule or something na para may pakita natin na may pattern. Pero for me po, for us to avoid being siguro masabit tayo sa contravening the decisions of the Supreme Court, dapat clearly po natin mapakita na may connection yung alleged actions niya when she was Vice Mayor to actions as Vice President po. Second, again, we keep mentioning po the intention to apply for subpoenas, for to check the bank records. So are we saying po na wala pa tayong ebidensya on these aspects? Kasi you mentioned you intend to apply pa lang po for these things.
Mga nabanggit na po yan sa mga
Nabanggit na?
dating mga hearings
by
sa Quadcom by the
Quadcom.
former Senator Antonio Trillanes. At he would be willing to execute an affidavit in that regard and also to testify before this committee. At meron din po tayong mga ipapaproduce sa AMLAC, sa Ombudsman, and sa bangko, yung mga sa bank accounts, the bank transactions of the Vice President, beginning when she was still Mayor, Vice Mayor, and all the way through her current incumbency as Vice President.
For the purpose of this fifth ground, Honorable De Lima, can you please share to the committee what so far are your evidence or attachments to the impeachment complaint? For the purpose of the fifth ground.
There are no attachments so far to this complaint because as I mentioned, the complainants will intend to prove this through those documents that will be the subject of the subpoena that we will request in due time.
Earlier, you made mention about former Senator Sonny Trillanes. And was this part or is this part of your allegation of facts in your impeachment complaint?
Yes, I believe so.
So there's a specific reference in the impeachment complaint with regards to the testimony of former Senator Sonny Trillanes during the hearing of the Good Government Committee.
We'll check, Madam Chair, but that is my
Yes,
recollection.
please. Yes, please.
Thank you.
Madam Chair.
Honorable Rodriguez.
Yeah, Madam Chair. The ground 4 is on page 95 of the complaint. And
We are on the fifth ground.
fifth ground is page 95 that the Vice President committed culpable violation of the Constitution, betrayed the public trust in amassing unexplained wealth and failing to disclose all their properties. Madam Chair, from paragraph 285 to 290 are conclusions of law citing the law itself, unexplained wealth, and also decisions of the Supreme Court. So let's go back to the statement of facts. The statement of facts, Madam Chair, is found on page 46. So this is entitled E, Facts in Relation to Vice President Sara's Unexplained Wealth and Failure to Disclose all her properties and interests in properties in her SAL-N. We must remember that Constitution says impeachment of the Vice President. And the Supreme Court ruled in Duterte versus House that those acts complained of for impeachment purposes should be acts committed at the time that he's holding that impeachable office. So therefore, paragraph 107, VP Sara served as Vice Mayor of Davao City between 2007 2010, then served as Mayor 2010 to 2022. Clearly, this is not within the Vice Presidency of Sara Duterte. So this allegation does not give substance to an offense committed by the Vice President. 108 is a listing of SAL-Ns, which are from 2007, 2017, that Vice President started to discharge her functions as Vice President in 2022. So clearly, 108 does not give substance to the offense charge. And lastly, there are only 3 paragraphs here in the statement of facts. Nothing, no recital of facts in the grounds under page 95 to 96. So here, number 109, more. Between 2006 and 2015, VP Sara had at least 111 million deposited in different banks in Davao City and Metro Manila. Again, nothing here pertains to the office of the Vice President, the acts of the Vice President of enriching herself as Vice President. Clearly, we cannot go to the future and say that in the future we can have, if there's a hearing, that they're going to fish for more evidence. Because we are deciding based on the recital of facts in the complaint. And it will never be taken up because they are not in the complaint. And the Vice President will be asked to answer those that are her own actuations and acts as Vice President. So clearly, Madam Chair, clearly, the ground for number 5 is totally devoid of any substance against the Vice President because all the acts stated, which is 107 to 109, pertains when she was Vice Mayor and Mayor. So this has to fail, Madam Chair.
Thank you. For the guidance of the members, the Chair wishes to manifest that the 5th ground of the 3rd impeachment complaint actually speaks of 2 specific acts. One is amassing unexplained wealth, and the other is the failure to disclose in the SALN. So, in relation to the Supreme Court decision, there might be an issue with respect to the first act. But if the failure to disclose in the SALN continues even to the time that she is already the Vice President, I think this will make a difference. The Honorable Suntay.
Thank you very much, Madam Chair. SALN violations require identification of specific undisclosed assets. The complaint does not identify any particular property or financial account which was omitted from the declaration. Without identifying the undisclosed assets, the allegation cannot establish falsity. We cannot also jump into a conclusion that what she owns is unexplained wealth without showing any proof. And as correctly pointed out by my 2 distinguished colleagues, the Vice Chairperson of this committee, Congressman Flores, and my esteemed former Dean of the College of San Sebastian Law School, Congressman Rufus Rodriguez. Actions to impeach the Vice President, it should be actions which is attributable to her during her term as Vice President. The non-declaration in her SALN in 2006 to 2015 clearly shows that these are SALNs when she was neither nor the Vice President, the sitting Vice President. Now, as also pointed out by our good colleague, Congresswoman Laila De Lima, wala pa silang proof. Papasupina pa lang. At the very most, this is a fishing expedition kung maghahanap pa lang tayo ng proof. Kung ang gagawin natin basihan, yung statements ni former Senator Sani Trillanes, then it is chismis and at very best, hearsay. Because it was already happened before. So, clearly, on this ground, there is clearly no basis, Madam Chair. Thank you very much.
I just wish to reiterate that earlier the endorser made mention of the allegations in the impeachment complaint that pertains to the testimony of former Senator Sani Trillanes, which is contained in the transcript of record of the hearing of the Good Government Committee. That is for the record. The Honorable De Lima.
Yes, Madam Chair, we confirm that there is a reference to the former Senator Trillanes in the footnote under the allegation, factual allegation, under paragraph
108.
Just for the record, Honorable De Lima, so is it correct to say that you are considering the transcript as evidence in support of the fifth ground?
Transcripts, because there was such a testimony. So it's not accurate to say that magkakaroon tayo ng fishing expedition because it was already mentioned in a previous testimony. And all we have to do is prove now, further prove it. Doon nga po, sasabi kong ipapasubmina po namin in due time, SALN's bank accounts and also from AMLAC, information from AMLAC, and that would be within the province of this committee to so issue such subpoena. So continuing nga po, tama po si Madam Chair kanina, yung na aspect ng non-declaration in the SALN. As Vice President, pwede pong i-connect din yan all these years na hindi siya nagdi-disclose ng mga wealth na grossly disproportionate to her lawful income and other sources of income. So yun po ang balak ng complainants. So we cannot really strictly limit this, yung allegations, we cannot strictly limit this to her incumbency as mayor and vice mayor. Doon nagsimula. Hanggang ngayon, hindi pa rin yan mga dinidisclose sa SALN. Thank you, Madam Chair.
Just for clarity and for the guidance of the justice members, it appears that the evidence on which the fifth ground is anchored is the testimony of the former Senator Sani Trillanes during the Good Government Committee hearing. So that is the transcript of records of the same hearing. The question, therefore, to the justice members is whether or not the transcript of the testimony of former senator will be sufficient for you to be satisfied in the determination of sufficiency in substance. The Honorable Rodriguez.
Madam Chair, we have to always look at the four corners of the complaint. And now, the endorser has cited footnote 98. Is that correct? Yes. If you will read footnote 98, it says, C. Trillanes accuses Duterte children of having 300 million in bank accounts. This is April 4, 2016, long before the vice president was elected and took office on June 30, 2022. So from all the four corners, nothing will justify. If he was trying to therefore say that there is another testimony, it should be stated here that in the hearings of the Quadcom, in the hearings of the Good Government. But based on the face of this document, there is nothing that will show there is a recital of fact that the Vice President has committed illegal acquisition of wealth. There's even no allegation in this state of facts on illegal acquisition of wealth. This is all SALN. And so therefore, Madam Chair, we can see that there is really nothing in this ground 5 to proceed because there is no such recital of facts of substance constituting the offense on this particular allegation of amassing unexplained wealth and failing to disclose her properties. Nothing, Madam Chair.
Honorable De Lima, would you like to respond?
Madam Chair, that even if there has been no definitive or explicit allegations within the four corners of the complaint about the unlawful acquisition of assets and property or wealth, unexplained wealth, with respect to her current incumbency as president. But as I said earlier, that it does not mean that we cannot include already acts. We cannot include acts that are attributed to her now that she is an incumbent vice president. And that it proves that yung pattern na yan na pag-acquire ng unexplained wealth at saka yung pagdi-disclose sa SALN is continues, or it continues, when she was or she is the Vice President. And that is precisely what is going to be established doon po sa mga documents na mga hihingin namin via subpoena. It establishes the pattern, yung accumulate niya ng ill-gotten wealth or unexplained wealth, and it hinges precisely on the issue of her fitness to continue public office.
All right. Any
Madam
other?
Chair, just a quick
The Honorable
manifestation.
Nasal.
I believe that the fifth grounds for impeachment against VP Sara Duterte should not be included due to lack of merit. Due to, number one, insufficiency in evidence. Allegations regarding bank transactions are speculative and fail to prove any illegal accumulation of wealth. And again, I agree with Vice Chair Keith Flores and my seatmate, Congressman Rufus Rodriguez, that the timing of offenses, impeachable acts must occur during the current incumbency. These claims involve actions from 2007 to 2017. And on lack of relevance, there is no direct link between past actions and her current conduct or fitness for office. And also, on unsubstantiated claims, the burden of proof has not been met as the allegations ignore legitimate income and constitutional disclosure rules. Also, supporting records from previous hearings lack the necessary credibility and relevance to the current charges. So in conclusion, I believe that the fifth ground fails to meet the constitutional and legal standards required for impeachment and should be dismissed. Thank you, Madam Chair.
The Honorable Zamora.
Madam Chair, if we're talking about legal standards, I think that we can allege acts that were committed prior to the incumbency of the official, so long as we are able to show that they are relevant to the charge that she also accumulated ill-gotten wealth after she was elected as Vice President, based on Rule 128 of the Rules of Court, which we may apply here, and also to prove, as stated by the Honorable Laila de Lima, that there is a system, scheme, or pattern, habit, custom, or usage, and the like, based on Rule 128 of the Rules of Court. Thank you, Madam Chair.
Any other member who wish to make a manifestation on the fifth ground? Would you like to wind up, Honorable de Lima, on the fifth ground?
Everything was said already. My insistence that is not going to be a violation of any principle in terms of alleging causes of action, because again, it's just a continuation. It's a show. It's a manifestation of the pattern of the official being impeached or being charged for impeachable offense. And this committee has broader discretion and authority to look into any related matter to the very offense that the respondent is being charged of. We have such broad authority to further inquire beyond those alleged acts committed during her incumbency during previous positions that are related again to the very issue of accountability and fitness to hold or continue holding public office. Thank you.
Again, for the guidance of the justice members, in addition to the theory of accumulation and the intention of the complainant to establish the pattern, we would like to invite the attention of the members that the fifth ground was drafted to show two specific acts. One is amassing unexplained wealth, and the other is the failure to disclose in SALN. So that is for the guidance of the justice members only. We are concluding our deliberation on the fifth ground of the third impeachment complaint. Now we proceed to the sixth ground of the third impeachment complaint. Please allow the chair to read. Vice President Duterte committed culpable violation of the Constitution and betrayed the public trust in committing acts of political destabilization and the high crimes of sedition and insurrection. Now let's hear the manifestation of the endorser. Honorable Dilima.
Thank you, Madam Chair. So the sixth and the last ground, acts aimed at destabilizing the government and inciting sedition and insurrection. Ang mga allegation po sa complaint, on the face of the complaint, noong January 28, 2024 at March 12, 2024, dumalo si VP Sara sa mga rally sa Davao kung saan kini-question ang legitimacy ng Pangulo at hinikayat umano ang militar na kumilos laban sa kanya.
Dumalo si VP Sara sa mga rally sa Davao.
Noong July 17, 2024, tinawag niya ang sarili ng designated survivor para sa SONA, as in paragraph 112. At noong August at October 2024 naman, hayagan niyang inatake ang Pangulo at sinabing nais umano niyang pugutan ng ulo ang presidente. That's paragraphs 113 to 114. Now, assuming truth of those allegations, the pleaded acts are framed as destabilization, incitement, and high crimes, falling within culpable violation and betrayal of public trust. Culpable violation of the Constitution. Kung ipagpapalagay na totoo ang mga alegasyon ng isang mataas na opisyal ng pamahalaan na nag-uudyok ng rebelyon, kini-question ang pagkalehitimo ng nakaupong Pangulo sa paraang maaaring magdulot ng destabilisasyon at gumagamit ng retorikang nagpapahiwatig ng labag sa konstitusyon na pagpapatalsik sa pwesto hindi dapat pinalalampas. This invites extra-constitutional disruption. Kung isang opisyal na nanumpang ipagtanggol ang konstitusyon ay kumilos sa paraang nag-uudyok ng kawalang katatagan o nagpapahina sa civilian authority over the military, ito ay tahasang pagyurak sa kaayusang konstitusyonal. On betrayal of public trust, kung totoo ang respondent ay lumahok sa mga gawaing nangihikayat na magsagawa ng rebelyon ng militar o hayagang naghahasik ng pagdududa sa lehitimong kapangyarihang konstitusyonal para magdulot ng destabilisasyon, ang ganitong gawain ay nagpapahina sa katatagan ng ating mga institusyon. Ang Vice Presidente o sino mang mataas na opisyal ay hindi karaniwang opisyal. Ang kanyang mga salita at kilos ay may bigat at impluensya. Kung ipagpapalagay na totoo ang aligasyon na nangihikayat pa siya ng destabilisasyon o kaguluhan, hindi na siya dapat pagkatiwalaan pa ng bayan. So that's the meat of the allegations in the complaint in relation to the ground 6.
Thank you, Madam Chair. Any member who has comment on the statements of the endorser?
Yes.
Congressman Rodriguez?
The allegation on paragraph on ground 6 is found in page 97, 98, and 99. Yes, of the complaint. In the grounds, it's stated here, 291, the Vice President desired destabilization. Again, she joined the hakbang na maisog prayer that encouraged the military rebellious action aimed at unseating President Marcos Jr. This is not complete because the statement of facts shows who are the persons who did this allegedly destabilization. So let's go to page 46. I'd like you to flash the statement of the Honorable De Lima yung grounds so that we can see that may disparity sa sinabi niya doon at saka itong 106. Can you flash again the first bullet?
Comsec.
Yes. Okay. Here, the first one. So this, okay, very clear. On January 20th, VP Sara joined the hakbang na may isug prayer in Davao City, where former president, so here there is no former president in the grounds. Clearly, the one, proposing and encouraging the military to take rebellious action against President Marcos was former President Rodrigo Duterte, not Vice President Sara. So very clear. In their own allegations, page 110, former President Rodrigo Duterte encouraged the military to rebellious action. There is no allegation here that the Vice President took the microphone and said, let us therefore take rebellious action against the President. So therefore, there is no basis for this to hold the Vice President accountable. Next, on March 12, 2024, she again appeared at a rally where statements were made questioning the legitimacy of the President. Now, where is Sara Duterte here? There is no statement here because here I have the page 1111 paragraph on March 12 exactly. During the rally, malicious statements were made to impugn the legitimacy. Where is Sara Duterte here impugning the legitimacy of the President? None, because she did not speak there. You see. So the second allegation has no basis. Okay. Third, designated survivor. We're going to a movie here of a film. We're using here the film to be a part of impeachment, the designated survivor. So therefore, there's no basis. Designated survivor. It can just be stated, as a matter of, that movie of designated survivor. So nothing really there that will destabilize. It does not say, let us remove the President. Nothing. Okay, then let's go to the third one. Here. The 113. Can we go to the next one after designated survivor? You're attacking and apologize. Let us go to what is stated here. On August 25, 2024, it's not the one there. What is stated here is the Vice President started publicly attacking the President. There is no quotation that she attacked the President. And then, period. This is the allegation in the complaint. She said, according to 113, on August 25, 2024, the Vice President started publicly attacking the President. What was said to attack the President? Nothing here because she did not say anything attacking the President. Here, the next sentence, she even apologized to members of the King of Jesus Christ, Kibolos Church, for campaigning and running with Vice President Marcos. Well, that is her opinion. Saying that, but she did not say, let us remove the President. Nothing of that sort. She just apologized that she campaigned and running with the President. Therefore, that particular allegation is not sufficient in substance. Now, we go to 114. Ito na. 114, she made pronouncements expressing a desire. Ano yun? 114. I will read to you. Then, on October 18, 2024, VP Sara made public pronouncements showing her desire to decapitate the President. Now, let's go, because it's stated here. Let's go to what is stated. Gusto kong tanggalin yung ulo niya ba? Gusto ko. Desire. I desire. Not a threat. Just a desire. Can we prosecute somebody with desire? Second, I imagine myself, imagination. Can imagination be a basis for impeachment? You see? And then she continued, hindi marunong maging presidente ang nakaupo. Well, that is her opinion. Are we going to also impeach her because of an opinion? Okay. And lastly, she said, Kung presidente niyo siya, okay lang. Tingnan mo, okay lang daw. Ako, hanggang vice president lang ako. Hanggang number 2 lang itong bansa na ito. Ulat itong number 1 para sa akin. So she's not recognized. So but is this therefore impeachable? Madam Chair, we believe that ground number 6 has no sufficiency in substance to say that she is destabilizing or the government or high crimes. In fact, our president is performing his duty. In fact, there is the military is not, is destabilizing the president. We are moving forward with President Ferdinand Bongbong Marcos. And so therefore, we do not see any effect of this. And so, Madam Chair, we are therefore saying that number 6 ground should fall. Thank you very much.
Thank you, Honorable Rodriguez. Now we recognize the Honorable Brian Poe.
Madam Chair, it brings me no joy to investigate a fellow public servant. However, I would be remiss in my duty as a Vice Chair not to study the facts of this impeachment complaint. With respect to a man I consider my mentor, very well argued. But for the sake of the body, I think it's very important for us to actually look at the context by which these events occurred. With the help of the ComSec, I'd like to request that the articles that were cited in the annex be displayed for the committee so that we can go through the events one by one.
You're requesting for?
I'm requesting for the articles that were cited in the annex of the impeachment.
Articles cited as annex of the impeachment complaint.
With reference to the January 28th date, the March 12th date, the July 17th, and the October 18th.
What are these articles all about?
So on the 28th, it is with regards to the rally at which the Vice President had attended. On March 12th, it is with regards to the remarks made by the Vice President against the President and his administration. On the July 17th, it is the article referring to the Vice President referring to herself as a designated survivor. And shortly after, on October 18, the article referring to when the Vice President had the desire to decapitate the President. These are the articles that would be flashed.
This is a total of 4 articles?
I believe, ComSec, is it we have 4 articles?
4 articles? 3.
3 articles.
3 articles. Okay, so with the indulgence of 2 articles.
2 articles.
With the indulgence of the Justice members, we would like to show the articles per request of the Honorable Vice Chair Brian Poe.
So, Madam Chair, this is the article regarding the rally that took place. And then the second article, please. And this is the other article for the prayer rally. Now, with the indulgence of the committee, since what's being discussed here are these dates, would it be possible for us to use the video clips that show the actual incidents themselves? Because if we're going to sit here and read the articles, it might be quite difficult. Anyway, this is for public consumption. We're not introducing new evidence here, and it's all on public record because these have been displayed on the news and in social media with the permission of the chair.
Madam Chair.
You're requesting for videos to be played.
Videos
of the same incident.
Yes. Yes, Madam
The Honorable Suntay, what's the pleasure of
Madam Chair, I would
Honorable
like to
Suntay?
reiterate the videos has not been attached as part of the complaint. And if
Are you opposing?
If what Congressman Poe states is accurate, that it has been shown on Facebook, on social media, widely, then there is no need to play it. Mag-aalas 3 na rin po kasi.
Yes, we are almost
Pa
done
ako.
with the first impeachment complaint. If the Honorable Suntay is not opposing the video, I think it needs to be shared to the Justice members for them to be guided in judging whether or not the requirement of the sufficiency in substance is met. The Honorable Ryan po.
Madam Chair, the videos are not being displayed to paint one side or the other, but merely to give context to what is being said here, because these events happened almost 2 years ago. So it's just for us to make an objective assessment on whether or not there's actually substance here.
So for the record, the video will be presented to guide the justice members in our determination of sufficiency in substance with respect to the sixth ground of the third impeachment complaint. Committee Secretariat is directed to play the video.
Madam Chair, I think for purposes of...
The Honorable Rodriguez.
Yeah, thank you. Chronologically presenting it, I think we should get the video first of the January 28, 2024. Is that the request of Congressman Brian?
Honorable po.
Yes, if we could do it chronologically, so that it also makes sense to the members of the committee, starting with January 28, 2024, then next would be March 12, 2024, and then after would be July 17, 2024, and then 18 October 2024. Again, with no predetermination as to whether or not there is sufficiency in substance, but just to give context to the arguments being made today.
All right. The COMSEC is directed to play the video chronologically, beginning with January 24, 2024 video and ending with October 18, 2024. This is a total of 4 videos. Can you play?
Mga kaigsunan ko, padayon nato nga mahalon ang atuang nasod. Mga kababayan, patuloy nating mahalin ang ating bayan. Mabuhay kayo, mabuhay ang Pilipinas.
Mr. President, pinilit ninyo kami. Kayo yung tinikit sa Bisaya, kinikitoy mo yung Pilipino. You are testing the waters, not even. You are, pushing to the limits ang pasensya ng Pilipino. Huwag mong gawin yan. Huwag mong gawin yan, huwag mong ituloyan kay magkagulo. Pag hindi namin napilitan kayo sa mga rallies, sa aming mga boses, ang sentimento namin, ako'y sinasabi ko sa military, nag-immorate ang bayan, gastos dito ng gastos doon. Tapos kung mag-dispatch, ang pinag-usapan ang putang inang kupring Pilipino. Gastos dito, gastos doon. Mga military, maawa kayo sa bayan. Pag hindi namin kaya, gawin ninyo. Gawin ninyo, kawawa ang Pilipino.
Yes, Dante, good evening.
Good evening, Harleen. In today's prayer rally conducted by the Sunshine Media Network International, or SMNI, and supporters of religious group leader Apollo Kibuloy, some former and incumbent government officials have attended the program. Vice President Sara Duterte arrived first, though she did not speak or give a message before the crowd. Before 8 o'clock tonight, former President Rodrigo Duterte arrived here at Diwasang Bonifacio in Manila. With him are Senators Christopher Lawrence Bongo, Ronald De La Rosa, and Robin Hood Padilla. Former presidential spokesman Harry Roque and former Chief Presidential Legal Counsel Salvador Panelo also arrived earlier. Senator De La Rosa said they came over to show support to Kibuloy. Meanwhile, former President Duterte urged the public to be vigilant, especially that the Marcos administration is allegedly now trying to amend the Constitution. Duterte said the current regime's main objective is to extend their term through charter change. He also emphasized that if any provision of the Constitution will be touched, the whole Constitution itself is now open for amendment. And that's our latest live from Manila. Back to you, Harleen.
Thank you, Dante. Amend.
Vice President Sara Duterte will not attend the third State of the Nation address of President Bongbong Marcos on July 22. In an ambush interview on Thursday, July 11, Duterte says she will skip this year's SONA. She also names herself the designated survivor.
No. No, I will not attend the SONA. I am appointing myself as the designated survivor.
A designated survivor is a U.S. government official chosen to stay at a secure location during events where top leaders are gathered. This ensures continuity of government in case a catastrophic event kills or incapacitates the president, vice president, and other top officials. There is no such position yet in the Philippines.
Well, nandun lang ako. Nakakatayo ako doon kasi may gamot ako. Gusto ko tanggalin yung ulo niya ba? I realized toxic na yung relationship. And it did not help na itong dalawang katabi ko, tumawa pa. Pinagtawanan pa nila yung bata. And I saw the humiliation sa face ng bata. I wanted to help him. Gusto ko sabihin sa kanya, itong relo ko na lang, relo ito ng Vice President, and ito relo ng Presidente, pero I hope this will do. And then I realized na baka mas lalo mapahiya yung bata if I do that. So I just imagined myself cutting his head. Gusto ko, ganun din ang gusto ko gawin doon sa mga katabi ko. So na-realize ko, toxic na ito. One of the graduation, hanapin niyo yung footage, makikita niyo doon yung mukha ko. Tsaka mukha niya. I-lip read niyo yung sinasabi niya. Why?
Honorable po?
Madam Chair, so again, since we were able to play these videos, we better understand the context of what had happened, what was said, and it is up to the committee to decide whether or not this is sufficient in substance. We are not debating whether or not there are grounds for impeachment yet. It's more of whether or not there's substance in what was submitted. And what we have is that she did attend those rallies and that she did make these statements. And so with regards to sufficiency and substance, it does seem that these are all included in the impeachment complaint.
Madam Chair.
The Honorable Suntay first, and then the Honorable Rodriguez.
Thank you very much, Madam Chair. Well, as we could see, based on the videos, lalong-lalo na yung una, statement ni BP Sara doon, patuloy natin mahalin ang ating bayan, which is very telling on kanyang disposition. Yung mga ibang videos, hindi ko na-explain because I will not be able to explain it anymore because I cannot explain it better than how my esteemed colleague Rufus Rodriguez explained it. Baka masira ko lang yung explanation niya kung tutulungan ko dahil maganda na yung explanation niya. Well, then dadako na lang tayo sa culpable violation of the Constitution. In the context of the Philippine Constitution and the ongoing 2026 impeachment proceedings, this proceeding, culpable violation of the Constitution is a high legal bar. It is not just about breaking the law, it is about a specific guilty breach of the fundamental law of the land. Kung ang pagbabasihan natin, yung mga pinakitang video, I don't think we will see any fundamental breach. The key word here is culpable, which implies a degree of perversity or guilt to commit this offense. The official must have acted with a deliberate intent to disregard the Constitution, which I believe is non-existing. Kung dadako naman tayo sa sedition at sasabihin natin, hindi. Seditious yung mga ginawa, kahit na nakita naman natin na hindi. Ang mahalagang tanong sa batas ay hindi lang kung nagpunta sa rally, nanood, o may nasabi ang isang opisyal. Ang importante kung may aktual na ginawa o inutusan na illegal na gawain. Kung ang allegation ay nakabase lamang sa mga speech, sa rally at mga statements, political rhetoric, I don't think that it is seditious. Alam ng mga kaibigan natin sa Makabayan yan, madalas silang mag-attend ng rally. Pero kung salita lang at wala naman silang ginagawang gagawing aktual, then that is covered by their freedom of speech and is not seditious. Thank you very much, Madam Chair.
Thank you. At this point, we recognize the Honorable Rodriguez.
We thank the Honorable Brian Poe because it's clearer now, based on the footage, that the Vice President did not in any way call to arms our people to rise against the government. On the contrary, love our country. Because sedition, Madam Chair, as stated here under this particular ground that the Vice President committed sedition. Sedition is committed, Madam Chair, by inciting through speech. No, we never heard any speech there. Writing or action, revolt or insurrection against established government authority, nothing. So therefore, the first allegation that the President, the Vice President destabilized the government, has incited sedition is not, or insurrection, because in that rally, even the President, former President Duterte was just saying, do not do all these things, do not spend this or that on do these things. And very clearly, VP Sara did not speak there. So that's the first one. So therefore, how can there be
Okay
an
guys,
action
continue
for
natin
sedition?
mamaya ulit kasi it's too long
Sara
na.
took part
Bye-bye.
in the
Thanks for
prayer. Yes, she
watching.
was seen there in the prayer with